In view of what has been concluded above, the court does not consider it necessary to go into the other points raised, as the court is satisfied that for the above reasons alone, the detention order stands vitiated. In the result, the impugned orders are set aside and quashed. Detainee is directed to be set at liberty if not wanted in any other case.
Deeply obliged.
May it please, Lordship. Oh, sorry.
I beg to mention item number 14 of today's list, Your Lordship. I am not taking time, Your Lordship. I just want to inform this honorable court that I have myself has withdrawn my Karatnama from this court, this case, Your Lordship.
For the respondent number
But
10, 11,
I am not
17.
taking time, Your Lordship, but just inform the court. Other counsel should be there.
Okay, deeply.
May I please, Your Lordship, so today's item number 26, bail hearing. So my learned friend has stated that a charge sheet has been filed, Lordship. I will appear before the learned court below.
Item 26.
26. TK Mishra.
Submission. That charge sheet has been and therefore
HCS number 152/25 dated 31/10/25.
this matter may be closed, allowing him the liberty to approach the trial court, the appropriate application, which allowed will.
Lordship.
May please, Your Lordship.
Yes.
I'd like to mention item number 6 of today's list. My lord, herein the petitioner has died. So I need 4 weeks' time to complete the legal heirs.
This is of 2014, sir.
Yes.
15th. Because this inquiry report was called for, and I have seen from the file also, the district judge has got for another 2 months' time. So let it come after 15th December. By that time, I'll implement if necessary.
The petitioner has submitted that the petitioner has expired in the meantime. Therefore, requires some accommodation to bring on record the heirs if required, full stop. Accordingly, list this matter on 15th
After 16th December.
December.
After ensuing winter vacation, Lordship.
Let January 2026 to enable him to take appropriate step.
I'm for respondent number 6, Lordship.
Take his
And case normal, Lordship.
Lordship, I am for respondent number 1 to 5. B. Goswami.
Obliged, Your Lordship.
May I please, Your Lordship?
attendance relation of kun Yes,
May I please, Your Lordship? I beg to mention item number 28, my lord.
28.
Yes, my lord.
Yes.
From court number 21, my lord. Can this matter taken some other day, my lord?
CD we have received.
A shorter day, my lord.
Huh?
Any day, my lord. First week of December.
Request of the learned counsel for the petitioner, let this matter be listed the next week.
Yes, my lord.
The
There is an interim order also, my lord.
Huh?
There is an interim order, my lord.
The next week, full stop,
second of December, my lord.
the 2nd of December.
My lord.
The December. Learned PT has submitted that the case diary has been. Time order passed earlier.
My lord. Obliged, my lord.
Yes,
May it
madam.
please, Lordship. Lordship, item number 7
Of
of daily list. Actually, Lordship, matter may be kindly taken up on next Tuesday. Actually, a new act has come. So we both party have to gone through this. Yes, Your Lordship.
consensus of the learned counsel for the parties list this matter. Again on, yes, give me a date.
Next Tuesday.
Next Tuesday. The 2nd. 2nd of December.
Okay, Lord, hearing for the respondent number 6, Your Lordship. Much obliged.
Yes.
Highly obliged.
Please, Your Lordship, I beg to mention for listing of a writ petition for withdrawal on Monday. Right.
May please, Lordship. I beg to mention item number 8, Lordship. Here we both the parties he's considered that he is Mr. Nandi is suffering from ailment. And my Purukasa sir also suffered injury and sleeping on the bathroom. So both the parties we have consensus. So maybe next week or so because it's a matter with
Done.
8.
Submitted at the bar that leading counsels of for both the contesting parties are not in a position to appear today. Their ailment, full stop. Request has been made to take up this matter again on, yes, what's the date?
Next week,
Your convenience. Give
next week, or first week of December.
Commencing 8th of December 2025 to enable the parties to have appearance ensured.
Mm.
Week commencing 8th, come up in that week.
8th, 8th December. Obliged.
Twenty-one.
May I please tell you? Regular bail application lordship. FIR page 9. Petitioner is behind the bar for 49 days as on date lordship. Page 9 lordship. Main allegation is against on Pallavi Shoikia lordship. And petitioner is a educational volunteer. He has no role in the recruitment process lordship. He gets salary only 5 up to 6,000 per month lordship against his service.
My lord,
Page 9 lordship.
a short that may be given and perusal of CD is necessary, my lord.
Huh?
Perusal of case that is necessary.
It is for 49 days lordship.
Hmm?
For 49 days he is banned.
No, Gaon. When?
My lord, on third.
So so appears for the petition.
Third of.
The application under section 483 of the NSS for grant of bail to the petitioner who was arrested on 10/10/2025, full stop. The allegations, the FIR reflect contents of the FIR reflect allegations of corruption and malpractices the DQM and the learned counsel for the petitioner submits that there is no allegation against the petitioner. Full stop. The PP has sought for some time to call for the CD. Stop. Let this matter be listed again on the 3rd of December 2025, by which time the updated CD shall be scan copy of
No,
the
no, CD.
Huh?
CD, my lord, case that is not scan.
of by the PP.
3rd of December.
3rd of December.
Must have list.
Since it's under 22C and lordship, charge sheet has been filed, trial has been commenced. The only
Scan
ground is
copy.
that, 26 witnesses to be examined, only 6 have been examined till date, lordship.
Present status report which the scan copy will come, my lord.
The short date may be fixed, lordship.
For the petition. Counsel on a another PP. And bail application of 83 of the grant of bail. The petitioner who is in custody since 23/4/25 in connection with in this case number 45. Wherein the trial has already commenced.
No, those.
And a PP has sought for some time. Call for the updated status. of
Which scan copy, my lord, scan copy of the record.
Status of the trial along with the scan copy of the trial. This
10th of
matter-
December.
Huh?
10th of December.
10th of December. Along with.
Lordship offense under
Huh?
Wildlife Protection Act, my.
Mm.
Now, my lord, in this case, lordship, FIR at page number 11, my.
Yes, Krishna, wildlife.
Wildlife.
Wildlife, Krishna.
Now, my lord, page 12, from page 11 onwards, my lord, the type copy, my. Now, my lord, in this case, lordship, The petitioners were arrested on 7/11/2025, my lord. Lordship got it, page number 11 is the, 12 is the FIR, my lord. Type copy. Now, Lordship, notice under 47 was, for the sake of argument, actually, in fact, it was not furnished to the petitioners, my lord. Now, record shows that it was furnished, my lord. My lord, kindly have a look at page number 18, my lord. 18, my lord, is a notice, my lord. In clear violation of recent Supreme Court judgment, my lord, Mihir Ranjan, my lord. Lordship, kindly have a look, notice 47, Hifzur Rahman. The signature is the bottom, my lord. Hifzur Rahman, my lord. And grounds, my lord, sufficient evidence found against you and you will be forwarded before the honorable court. Notice has been explained to the accused in Hindi language and he understood and acknowledged the same. Now, my lord, section, there are 56 of recent judgment of apex court, my lord. Lordship, I will produce.
Yes.
My lord, we have not been
Conclusion, it is held
served
that
a
the
copy, my lord.
It was furnished, my lord. Furnished, my lord. It's still furnished too. It's pending us. Special people one.
Talukdar PN Goswami.
Then, my lord, I'll have to take it, my lord, because we have not been given the copy yet. May I pray for
Talukdar.
a date tomorrow, my lord?
Tomorrow.
Right.
Give him a copy tomorrow, we'll see.
Lord.
This matter again tomorrow. So for the petition, give a copy.
I'll.
PP, yes. I'll connect it.
Now, my lord, in this case, charge sheeted, my lord, scan copy of the case may be called. Scan copy may be called.
Commercial quantity.
Commercial quantity.
Item 3 logo take the one. Under section connection with 5 rising out of 5 file has commenced. Then PP pays for time to this for the scan copy of
10th of December.
same.
Obliged.
Wait, please, your lordship, an application under 483 of the BN.
Ah,
Your lordship, here, the petitioner has been arrested on 25/10/25. Now, your lordship, in this POXO is there, therefore, your lordship may call for the CD and as well as notice may be issued to respondent too.
note আছে issue notice blended PP appears issue notice 2 party number 2 through the police station.
No,
No,
Malat,
it's
it
through the-
through the registry routing through our office, Malat, PP office, Malat. As per the prevailing notification, Malat, that will be better, Malat. There is a notification. As per the prevailing notification.
There is a notification which says it will go through the office of the PP.
To the updated case diary in the meantime.
Malat, on 9th of
Hello, what did you- Just because the boys in class 12
Lakhimpur.
and exams are there in.
But
February.
notice has to be served. Malat,
Yes.
today is 27, but they will take notice when CD is from Lakhimpur, Malat.
Lock him.
You are bringing a scan copy, you are bringing the original CD.
No, this.
Here, Shasid not submitted, CD will come.
Take-
Notice has to be served.
Notice on part the
Yeah, 5th.
Obliged.
Here, Malat, actually, earlier case was of Kajalgaon. That was now renumbered as transferred to Bongaigaon. and there is a separate case registered in Bongaigaon. So that CD has to be called for, but none appears from the petitioner. Earlier CD of Kajalgaon PS case was called, as notice already served, POXO case, notice served.
Notice, sir.
Notice, sir. But now it has been transferred to Bongaigaon and there is a new number in Bongaigaon PS 250/25. So that CD you have to call. Otherwise,
One appears for the petitioner on call. Submitted by the that
Kajalgaon PS case number 144/25 has been transferred to Bongaigaon.
and has been registered as
Bongaigaon PS case number 258/25. So calling for the CD of that.
that was an order on 13/11/2025.
Or
State respondent who submits that some more time may be granted to call for the case diary.
that CD has not been received, my lord.
Again on when?
My lord, 5th.
5th of December. None appears to লিখিছে তো? কোৱা নাই নেকি?
Here also, Malat, they have taken steps on 10th of 11, and we have sent on only 11th of November. So service not complete, Malat, and
11 to 27 not complete. Please.
no, on 10th of 11, they have taken steps,
10th of November, they have taken steps.
and we have sent on 11th of November.
Today we are on 27th of November, 16 days.
Malat, Malat, it is not received.
Huh?
Status report also not received, Malat.
Find out. One appears for the call. He has some status report on the service of.
We need to
upon the respondent.
service report. Malat.
What about the part?
Service report.
Huh?
Next.
Only the service report. Trial has not started. Service report. List again on when?
5th. BA.
5th. 14 days not received. You'll receive it in.
Well, we have sent, but not given. We have not been informed by the next day. We'll definitely.
Yes.
27 charge sheet submitted.
Yes, sir. Charge sheet
Maybe.
submitted.
If you may admit absolute, because I'm the father, brother of the main accused, my lord. This is, I'm an interim, my lord. This is the order of the main
Charge sheet
accused.
say. Anything against you?
Charge sheet details is not available. Only we have the signal, only number and date.
The FIR lordship only allegations against my son, my lord. He allegedly by using deceitful means established sexual relations with the woman, my lord.
Statements record.
Yes, yes, appeared, my lord. This is the order of the main accused.
Hmm?
Order of the main accused, it was made absolutely.
Vidya Barman.
With the
Mr. Sir. Who has submitted that the charge sheet has been submitted.
It's CS number 106/25, dated 29/9/25.
Council for this. Order dated 19/2003. Number 1. Whereby the main accused interim protection main accused. Absolute. It is seen that the petitioners are the
Father and brothers.
owners of the Burman, who was the by an order subject self and has been made the above free instruction granted by the order dated
23/7/25. I'm obliged, my lord, highly obliged. Obliged.
In this case, one of the petitioner is in interim lordship. Last occasion, amicus curiae was appointed in this case lordship.
That's my number.
After. the
Service
interim-
complete, but CD we have not received, my lord.
Huh?
That service complete he has appeared, but CD not received.
so and so appear.
No,
The
no, CD.
petitioner, Mr. Respondent number. Has submitted that
Yes, that is not
it has
received.
not been received. List again on
My lord, Jinja 8, my lord.
the 8th of December interim.
Interim. Obliged.
Wait, please, your lordship.
Is
Your lordship, on 7/11, the CD was called, but on 2 occasions, CD was not received. There is no news about the notice served on the respondent number 2 as well.
Yes,
So,
my lord.
your lordship, Micus may be appointed and maybe prosecution can shed some light as to the status of the CD.
The status also we have not received. We have sent from our office, my lord. On 10th. 10th, no,
10/11.
10/11.
Should someone come from there bringing the status?
And CD also not received, my lord.
We ask someone to come with everything.
My lord, next day, my lord, next week, my lord.
Lordship and Amicus may also be appointed.
Not know whether they have been served, whether they would like an amicus or have their own concept.
Any day, next
Unless
week.
they
My
are
urgent,
served, then
maybe
it
on
is for
4th,
them.
4th, my
They
lord.
can have an amicus.
So therefore, sir,
They
lordship
may
may
have
fix
their
a
own idea of
shorter date.
whom to engage.
On 4th, my
Lordship
lord.
may then fix a shorter date, then they can determine
On the next
whether-
week. On the next week. Wait on the next.
a fixed date if possible.
Yes, 4th of December, my lord.
Much obliged, your lordship.
Do not know whether they have been served.
No.
Yet to be informed whether notice provided with the updated CD full stop. This were issued on 6/11/2025. The learned APP submits that they had conveyed information on 7/11/2025 itself full stop the matter on 8th. When?
Fourth.
On 4th of December 2025, by which time notice shall ensure the requisite information is provided to the
Much obliged, your lordship.
economic.
Look, I'm extremely sorry, Malay. Item 25 could not come reach today only.
5.
25 Malay. I'm searching for 21 Malay code number.
What did we say in 25?
TCS. Look,
Huh?
petitioner behind was more than 127.
5/12.
No, service report is fixed on 5/12.
Service note.
On fifth.
But-
TCR is there. TCR is.
I'm extremely sorry, my lord. Deeply noted.
My lord, our instructions are awaited, my lord. I'm
Huh?
praying. Instructions are awaited, my lord.
Already notice issued, my lord, in
Hmm.
this case, my lord.
Notice issued, my lord.
When?
After 10 days, my lord.
Mr. S. Kotakul. The Bothakul on a council paying for the respondents has said that may be accommodated for 10 days. Allow him to
Milord.
have
2 weeks,
instructions,
maybe also.
to, have his instructions in the matter, full stop, list the matter again after it to be fixed by the registry. Stop, same order passed earlier shall continue.
No,
It
Milord,
is without view of the court.
interim order until further order is there, Milord, not necessary. Milord.
না লাগে, in time to না লাগে।
Milord, let this be listed along with 618925, similar
He
matter.
has submitted that the matter may be listed along with WPC number
618925.
of 25. Registry to list both the case.
May it please your lordship.
Yes, madam.
My lord, here I am aggrieved by the order passed by the appellate authority RERA, where my lord, I am supposed, under the statutory provisions, I am supposed to deposit a pre-deposit for filing an appeal. Now, the facts and circumstances in the case is like this. My lord, the husband of the petitioner was the actual promoter of the project. Now, during his lifetime, he suffered some kidney issues and he died. Now, when he was suffering for his ailment, he could not complete the project. And in the meantime, he has also accepted some amount of money from the buyers. A few of them had paid the entire amount also. There are some buyers. Now, at such point of time, when he was in extreme need of money, then he entered into an agreement with another person called Madhav Sharma. Now, this was done, my lord, admittedly after the enforcement of RERA, my lord. I mean, RERA came into existence. But this transfer was not registered with RERA, my lord. This is admitted, my lord. So now the person to whom this is transferred, he has taken possession of the entire project. In the terms of the agreement, it was a registered agreement, my lord. The agreement is still in force, my lord. It has not been cancelled by any authority. So in the terms of the agreement was like that, whatever amount has been taken by the previous promoter, that will not be reversed. And the new promoter, if he wants to enter into some fresh agreement with the buyers, those who have not paid he can take that amount of money. And if he wants to extend the extent of the project, that also he was entitled to. So under these facts and circumstances, this complainant had paid the entire amount prior to the transfer. And then, my lord, what has happened before the death of this original proprietor, he had made a complaint before the RERA that I have paid the entire amount and then the project is not, I mean, the flat is not handed over to me. During the pendency of that proceeding, he dies. Now, his wife, this person, now here, the company has been, my lord, implemented as party. Their Brishwati RERA, Gargi Associates. The present petitioner was a director in the company. Now that company has become defunct after death of the proprietor. I mean the promoter. She is also nowhere. All her properties have been attached and sold off by in the debt recovery proceedings. There were bad loans and also she is now not in the affairs of the company. The company has not been, my lord, functioning as on date. And then, my lord, a company cannot, a private limited company cannot run with one member. So it should have been her personal liability. But anyway, my lord, she was sued as director of the company. If I can take your lordship to annexure 1, the initial complaint before the RERA. My lord, it is not that the complainant was not aware that the possession has been transferred to the fresh promoter. In the complaint itself, he says that he had meeting 3 times, he had meeting with the new promoter. But then he has not been implicated as a party respondent there. Now, my problem is, my lord, why I am before your lordship, this aspect of the matter that the project was handed over to a fresh, a new promoter was not taken into account by the RERA. I go and then compensation was awarded. Now, I'm a pauper, my lord. I'm in no position to pay the compensation. And where do I pay? How do I pay, my lord? Possession has been handed over to someone else. And if the possession is, my lord, reverted, in that case, of course, I can sell it off and I can pay him whatever he wants. But the fact remains, and this particular fact that it has already been handed over to another person who is not a party before the proceeding. My lord, he was never made a party, in spite of repeatedly bringing this to the notice of.
What is your challenge?
My challenge here is I want to pursue my appeal, because appeal is not, my lord, decided on merit. Only to the extent that I am not able to pay the pre-deposit, therefore the appeal is not admitted. Now, my lord, I am before your lordship, that lordship may kindly waive the pre-deposit, and I am ready to go before. I am not bypassing the authority, the appellate authority. I'll go and conduct.
Can we do that?
My lord.
When there is a statutory
I
requirement of
understand,
a
my lord, that
pre-deposit,
I
the report
understand.
said no.
But in a given case, my lord, I think lordships can interfere, my lord.
Show us
My lord.
something. Show.
And my lord, in the act itself also, there is no such provision that it can be waived. In other acts, my lord, there are provisions that it can be waived in certain circumstances. In this particular manner, RERA, my lord, there is no such provision, and therefore I am before your lordship in a 226 proceeding. To that limited extent that I would go.
Even to entertain the appeal, suppose you file a writ petition, you file a statute, anything you file, there's a court fee, there's some fee
My
to
lord,
be paid,
my lord.
some pre-deposit to be made.
My lord.
Wherever the law provides that that's
My lord,
a prerequisite.
My lord, here is the case, my lord, I'm not entitled to pay. So if I'm not entitled to pay at all, this pre-deposit, my lord, in my humble submission, my lord.
Law
would not
does
be-
not take that into account, does it?
My lord,
The act does not take that
that
into
is the
account.
problem, my lord. The act is silent on these issues, my lord.
The deposit you will get back. If you win the appeal, that pre-deposit will
The
be
problem
given
is
back.
where do I get this money to deposit? And then the actual person who is in possession of the property, he has not been brought into the proceedings, my lord. My lord, courts cannot close its eyes a practical situation, my lord.
That you are not the appropriate person to. You did not participate in the before the thing.
My
The
lord.
first. The first litigation you did not.
I participated, my lord.
You participated.
My lord, I participated.
There you
I
did not
brought,
take up this ground that yes,
Yes.
this man is to be brought in.
my lord, I had, this is there.
What did they say?
Nothing is said on this issue, my lord, regarding
They
improvement of,
brought up this issue. Where do we find it?
my lord.
Is no longer with you and someone else should be
Man.
held responsible.
My lord, lordship may kindly come to page number 19, annexure 2,
19.
my lord. Paragraph number 3.
The last occasion we had raised some query.
And then my written argument also, Lordship finds at page 35,
Hmm.
page 36, paragraph 4.
But the company is not liquidated.
My lord, company is
Therefore,
also
the
not
liability of the
liquidated
company
officially.
remains.
Company is not officially liquidated.
Huh?
Company is not officially liquidated, my lord.
Then have the company liquidated, pay off whatever dues can be paid off.
But my lord,
As you hold the company also.
my lord, if the complainant, he wants, his concern is his property.
Hmm.
So he should approach the right person who is in possession. Entire property has been now with
That
the.
is what has been decided. First round of litigation. Want to bring in this ground of litigation. For that, there is a statutory requirement to pre-deposit a certain amount. Company that you represent, it is not going into liquidation. You say you don't have money. So take cognizance of those facts. That the company exists, it's not in liquidation, money is owed. Difficult. So as from somewhere that this court can say yes, even if there's a pre-deposit, just waive it. It is not even at the stage of the waiver that you are coming a prayer for waiver. You made an you gave an assurance to the,
That was my lord without.
then it
least-
was withdrawn.
The
That is-
petitioner says that it was not per her instruction, whatever may be, that, yeah.
I
According
think yesterday the judgment has come out. If
to
yesterday,
somebody else, that she did
litigants
say.
will not be allowed to hide behind their lawyers saying, I did not give instruction.
Well, I'm not, that is not my case also. The fact remains that she wants to pursue the appeal, but for this difficulty of pre-deposit.
Without
And then, my
company-
lord, if I may take your lordship to
Without the
this aspect,
company going into liquidation,
my lord.
when a director stand up to say that my company will stand, I
Actually-
want to file an appeal, I do not have the money, I don't.
Actually, I was doing some research on this
Ah.
issue, my lord.
You found
I
something?
didn't come across the appropriate one.
Ah.
But there are some judgments I found where the apex court did not come straightway saying that no, High Court can, honestly speaking, my lord, that High Court has jurisdiction and High Court can give a direction to waive the pre-deposit. But there are cases also, the court was little lenient on this issue. In a case where FEMA was in question, the court said, okay, that High Court, it is a 226 jurisdiction for High Court will take into consideration the prejudice caused to the, and there another aspect was that prejudice was included in that definition. Here we don't have that also. But prejudice has been caused, High Court will not close its eye. And then a certain percentage was deposited, the apex court said High Court can.
In this act, do you have anything where the appellate authority can say that, okay, we can consider and you did not deposit the entire amount?
That is not there in this act, my lord.
Then-
It is not there in this act, my lord. But my lord, if we are concerned about this complainant getting money, then money will only come from the person who is in possession. That also remains the fact. They may put me behind the bars. In the Bakijai proceeding, I'm a pauper, my lord. I cannot pay, admitted, because everything has been attached
You
to.
have to file a proper certificate, then proper, you go for the proper process of law. Declare yourself a proper to have the company liquidated, whatever you want to.
My lord.
Those will be the appropriate.
So may I pray, my lord, let this come on Monday or Tuesday. I want to make some more research on this issue, my lord. Although I have come across one or two judgments, my lord, if I may refer to 2010 4 SCC,
You want to have something more on Monday, we can allow that.
my lord. But I myself, I'm not very happy with the,
Will only be delaying the outcome. We'll have to release it.
technically, my lord,
Huh?
we are stuck up, I understand, my lord, technically speaking, and then High Court has.
No, these are technicalities which, with the best of our intentions, we cannot overcome.
I understand, my lord, your lordship has.
An appeal needs to be heard. We understand that.
my lord,
Appeal is a statutory right. You need to be heard. We understand that.
Yes, my lord.
But if the law which is giving you that right, it says the deposit,
My lord.
and you do not take steps to show that you cannot deposit, but you take further time. Then you do not deposit, and then the appellate
My lord.
authority says nothing.
Mm.
Cost and how can we interfere in that part? We cannot look into the logic behind the reasoning. We can only look whether there was a reason to do so, whether it was done correctly. Want it on Monday,
Monday,
then it goes.
Monday or Tuesday, my lord.
Release it then.
Lordship may not release it because some deliberations are, and just on this issue, my lord, on the,
Please say.
that it on Tuesday or hearing.
Otherwise, there is no relaxation. It's a mandatory provision, you know, that has to be deposited.
But
Admitted
then
that.
again, also you are you say barking up the wrong tree.
And lordship, she is only pretending. She has sufficient immovable property.
Let them come up with
As
that.
per my
Let them come up.
I will leave it to you then.
My lord.
At the request of the learned counsel. Commissioner. Attendance to mark. And council. And on the 2nd of December,
Second.
to enable her to.
Second.
At the request for further hearing. Tuesday either
Miscellaneous day, right? Let it be on a.
What she guess?
Tuesday.
Tuesday.
Much of it.
May I please your lordship. Your lordship may kindly take up the matter after some time.
After some time.
Yes. Obliged.
Is that wine shop thing?
Yes, lordship.
My lord, there's a similar order, my lord,
Ah.
where the coordinate bench has asked us to, my lord, adhere to the directions as per the PIL suo moto number 1 of 2022 and shall be restricted to reserve forest area only. My lord, that
My lord, our case is that we are not fall under the reserve
No,
forest area.
whether you fall under the area or not is something that will have to come up by some identification process carried out by them.
But that.
Along with you.
Yes.
So before they enter your land, they will give you a notice saying that, yes, you are in the forest land according to us. Show us that you are not. You
Yes.
will ask for a demarcation. They will do whatever is required.
Yes,
Those are things which will happen on the field.
on the field.
So far as this court is concerned, you are aggrieved by a notice which has been given to you. They want to enter upon your land.
Yes.
PIL order has said that you will not enter into the land if it is not a reserve forest. First, they will show you
Yeah.
that it is a reserve forest, then they will enter
Yes.
if necessary.
And in the affidavit of,
Kindly go through that order in the PIL. Have you gone through the order?
yes, that order I have
I think that part.
My lord, only thing is that in the affidavit filed by the government, they are specifically stated that it has not been demarcated.
We will take that into consideration.
And in that part also may be taken into consideration.
We will.
Based
quote
on
what
forest
they have
record,
said.
the
Prayer number,
exact,
page number.
it is affidavit filed by respondent number 4. page 99, kindly see. The exact boundary of reserve forest could not be ascertained during survey by the forest department.
They do not say that your land does not fall in it. So therefore, the
No, no,
moment
with
this
respect to our amendment made in the writ petition, they have stated this.
PL says that it will not be done without demarcation.
Yes, but in my case also, no demarcation has been made, and they are issued notice and try to encroach upon my patta land.
What is the order that you?
Well, without demarcation, they should not be evicted us.
So the PL says. That is how we will,
Yeah.
we will have the order flown.
Yeah.
We are setting aside the notices.
Now, for my affidavit, page 95, no notice has been issued, madam. That is my specific.
General notice. There was a
General
general
notice.
notice. Since it does not, it is not a specific notice. Those notices will not be held against them. To be notices against them. In case the respondents want to come into their land, specific notices.
Yes,
to
yes,
persons
yes, that
who
can
are
be done.
found in, physical possession of the land.
Yes. that
With
can be-
specific details as to how you say that the land falls within your government,
Or forest.
Reserve
man.
forest.
My lord, they will have to come and show.
you will give them the notice saying that
Yes,
this
yes,
is
notice,
reserved.
yes,
This is why we think it is reserved. And they will come back to show you that no, this is not reserved.
Okay. That can be.
That is how it happens.
Yeah.
Some orders passed regarding that Fasil Ambari Reserve Forest also, I think we have passed some order on that line. Okay, then we'll,
Online, my lord, notice will have to give.
Huh?
Online notice will have.
No, patta land,
Now, they are
notice
giving
we
it's a
have to
patta
give
land.
only reserve forest land, not over the patta land.
No, no,
There are
if-
separate procedure, my lord.
No, no, if.
For
government
acquisition or
declare-
acquisition
Yes,
of the
yes,
patta
yes,
land.
I mean that only, because your case is that you got a patta land.
those cases where they did not have patta land. Acha
Yes.
just patta, but I think also in some cases they had patta land.
No, the government land. Government khas land. Where in this case, our case is that patta land.
So this notice annexure 2 is a general notice
Then.
which does not suffice the requirements of law, is it? Page number, sir, annexure 2?
Page number 57, translated copy, and page 58 is the
Yes.
vernacular one. For the general notice.
The general notice does not suffice the
Yes.
requirements
Yes.
and following the PL and other judgments of this court and the Supreme Court,
Yes.
without following the due procedure of law as required, you would
Yes.
not be disturbing their possession where they claim it is to be a patta land. On receipt of notice, they would be at liberty to show that it is a patta land
Pattern.
Yes.
and therefore not to encroach.
Yes.
What is sufficient time given?
You'll have the order tomorrow.
No
Pass the
problem.
orders in the chamber, but that is the operative part.
Yes.
Much
This
obliged.
notice is a general notice, not related to the petitioners directly. Moreover, since they claim it is a patta land, before you do anything, give them the appropriate notice as required in law. They would be under the liberty to have their say in the matter. Thereafter, you can
Yes, sir.
Much.
Problem.
dispose it. Eleven.
My lord, in this matter, I am preparing a short synopsis of my arguments. I'll submit it today during the course of the day.
Well, I have already submitted my part of the argument.
So, you say that there is a, since he has stepped into the shoes of the earlier debtor, let us say a debtor, therefore he has to pay what the debtor owed you. He says, I'm ready to pay up to the extent that it is lawful and legal.
Yes, yes.
Anything beyond 15 days from your notice of permanent disconnection, anything beyond that, I am not supposed to pay. That is his case.
Yes.
That is all.
Yes.
The charge part, that surcharge part will depend on whether it was an conversion from LT to HT,
Yes.
whether it was an HT, whether simply raising the supply demand would
Yes.
fall into that portion or not. That is the issue.
Absolutely, my lord.
Give it to us, we'll
Very good.
Deeply obliged.
Lordship, হেৰি কৰি দিয়ক, third learned councils, attendance to deliver learned councils, parties, full stop. Arguments concluded, judgment reserved. Yes,
Very, very good.
you give whatever you want.
Yes.
CAV কৰিব, huh?
My lord,
Hmm.
that will be adjourned for the time, adjourned for the time being.
Adjournment for the time being. Adjourn for the time being.
My lord, anyway, I'll be taking some time for filing affidavit. Instructions have come, my lord, for Water Resource Department.
Late than in our court.
No, tell us anything urgent that it should be taken up today.
Instructions have come, so I can file my affidavit within 2
What is
weeks.
the prayer?
It is regarding land acquisition, my lord, non-payment of.
We'll allow her to file the affidavit, give her 2 weeks' time. Will be listed after 2 weeks, we'll record your presence. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Ms. P. Bhattacharjee learned. P. Chakraborty learned counsel appearing for the respondent number
4, my lord.
4, who submits that instructions have been received and the affidavit will be filed within a period of 2 weeks, full stop. Mr. Das and Mr. Bodley also appear for their respective respondents, full stop. Is this matter again after 2 weeks on a date to be fixed by the registry, by which time the learned counsel, the respondents shall ensure filing of their response to the repetition. 2 weeks, yes.
Obliged.
Look, this morning, Santanu Porter called me and informed me that he has withdrawn from the case.
Yes. We were also told so in the morning. We
Yes.
told someone else's
My
representative.
lord, I am today, I will file, my lord, on behalf of respondent on 19 and 20.
Hmm.
Aadhar will come. Only 19 and 20. I have filed local account.
Ah,
And possibly what had happened, earlier there were no Ukalatnama for the respondent. Somehow things were going on.
Only one caveat.
There was only one caveator and the respondents are 20, na? 20. 5 to 20. So
now you are appearing for
19 and 20.
19 and 20.
19 was the caveat.
That we have filed one written objection. And they were the caveator also. my lord.
Only 19.
Item, respondent number 19 was the caveator also.
But others notice has to go or
Notice has, it has gone, my lord, long back.
yes, as Bhattacharjee accepts notice on behalf of 5 to 20.
Ah,
So if only 19, 20 were to be represented by him, 5 to 18, I think notices have to go.
now,
Now it has to go.
how to go?
No other way. They will not be in the knowledge of
Correct.
proceedings.
কিন্তু আমার in the meantime,
10, 11, 17. Just a minute. You are appearing for 10, 11, 17. You are appearing for
19 and 20.
19 and 20.
That means 4 are before
One-
your lordships.
1, 2, 3, and 4 for state corporation
One,
department.
1 to 4 represented. Anybody else? No.
As far as
Yes,
state
sir, now-
respondent is concerned, there is no issue.
That is 1 to 4.
Yes, Katal.
1 to 4 he
There is no
represents.
issue. my lord.
5 to 9, 12 to 16
And 18.
Huh?
And 18.
and 8. No, 5 to 9
That's right. 5 to 9, 12 to 16, and 18.
and 18. Yes, okay. And 18.
The objection which has been filed, my lord, it is for 5 to 20.
Yes, my lord.
Yes, my lord. Therefore, my lord, I prayed, my lord, to withdraw this petition. That you will
You
have
are
to file.
appearing for 19 and 20.
Yes.
who has signed it, 19 or 20? Who filed? 19 signed it. File an affidavit saying that it was an inadvertent mistake and it will only be for 19 and 20.
Worship,
But we don't have that objection on record.
Worship, I have filed an intervening application. It has been listed here. Worship. It is 3813.
So who are you?
I am the others flat owners who want to support the stand of the petitioner. We have filed an application for intervening and it has been listed as IA 3813.
My lord, in this case, of course, we are fighting, my lord, but the stand of the government is very important. They are keeping mum, they are not saying anything. They should file their affidavit, my lord.
Do we
I
have
think it is
received
the
the
government stand
instructions?
which
My
will
lord?
be-
We have received the instruction. My lord, we need some.
Let 10 days time be granted, my lord. Let them file their counter, my lord, because there is some urgency in the matter. Because the one-man committee, my lord, he has, my lord, virtually taken over everything.
Oh.
He has been restrained from holding election. There is an interim order. But, my lord, other than that, he is doing everything.
Then speed up matters permit you on Dusty.
Lordship will permit us Dusty, my lord.
Other
No?
already
Dusty,
represented.
no.
But for cooperation department, my lord. My lord,
Okay, heard Mr. Kane, senior counsel appearing with the assistance of Mr. For the petitioners, full stop. Also heard so appearing for the respondent number 1 to 4, full stop. Your good name, sir?
Yes, sir.
Appears for the respondent number 19 and 20. 17, full stop. It appears that initially notices were received on behalf of the respondent number 523 by the caveat, by the council appearing for the caveator, full stop. Today is submitted at the bar that all the respondents from 5 to 20 would not be represented by the sole council. Full stop. And stop. Respondents number 10, 11, 17, 19, and 20 are represented by their respective councils. So, the above view of the matter, let notices be to the respondent number 5, 6, 7, 8, 9, 12, 13, 14, 16, and 18 by speed post. Stop. Petitioner to take steps within 3 working days. Stop. Since the matter relates to the operation of a cooperative society, which is now being run by a one-man committee, we also allow the petitioner to take steps of service of notice upon the respondents number 5 to 9, by way of Dusty to be read through the registry of this court. Full stop. Just after 3 weeks.
2 weeks, man.
2 weeks on a date to be fixed by the stop. The respondent authorities are yet to file their response to the
Writ petition.
writ petition. Full stop. Notices were issued in September 2025. Full stop. Respondents are expected to have their response on record on or before the next date of listing.
Can you pray for 17 December?
Next matter again on 17th.
1/7.
Immediately before the vacation, it will be motion days. 17th of.
Or
This is the
16 Tuesday.
This is the matter again on Thursday.
Worship, my higher may be.
December 2024, full stop. Then there is one I.
My lord, I may be allowed to file affidavit, my lord, to correction of.
That will be upon you to do so. Should I be saying that in the order that you were filing it
They can
without?
take a seeking leave of this honorable court, they can file it.
all respondents would be at liberty to have their affidavits filed on or before the whatever affidavit you want. I will not point it out in the order that there was a mistake. Why should? In civil of 3813 of 2025, this application has been filed by the applicants seeking to intervene in this writ petition. Full stop. Should notice
Notice I have already served upon all the
appearing persons.
Mr. Shantanu, earlier he received, but, and I have also served
It,
upon
it
him. also.
really disturbs us when you take our
Yes, I understand.
issue notice on the opposite parties, full stop. You are appearing for opposite party number. Please give us the numbers of the parties. Opposite party number so and so, they'll give it to you in writing, huh? And so accept notice on behalf of party number so and so. Notice on the meaning opposite parties number, those who are not represented, no? Right? The opposite party number so and so by registered AD as well as Dusty.
Highly obliged.
Is this matter along with WPC number 5766 on the next date to enable consideration of the prayer for intervening?
Deeply.
From the same.
Interim will continue.
The interim order passed earlier in the writ petition continue. This will, this in continuation of the interim order, you write in the writ petition. Not in the interlocutor.
Deeply.
Highly obliged.
Lordship should kindly have a look at the last order on 30/10/25. My lord, I don't work alone.
I was trying to explain the circumstances under which the
Very, very. My lord, in this case, possibly, my lord, one aspect has to be considered. The tenant, Mahmudul, after the kiosk was removed by the GMC, he filed a writ petition. And in the writ petition, he has taken a specific stand. It was his thing. Lordship, kindly. So that's why I want to bring it on record. He has in the paragraph 12 of his writ petition, he has stated like this, that suddenly on the night of 18th March 25, at around 10:45 PM in the absence of the petitioner, some officials representing themselves to be from the GMC, visited the site of his shop kiosk and forcibly took away the iron frame.
Now, is it the stand of the respondents here?
My lord.
That because of the orders passed in the second writ petition, the other writ petition by Mamadul, therefore we are not.
No. Well, first of all, this bamboo structure, if any, it was erected and put up by the tenant. That is what I want to show, my lord. Tenant has taken a stand in his writ petition because he filed a petition challenging the action of the GMC. There he writes that no notice under section 337 of the GMC Act 1970 was ever issued to the petitioner before initiating the such actions. Now, presently the petitioner is having to operate his shop kiosk from a temporary shelter. And so far as the structure outside his shop is concerned, he is not a tenant. He can be a tenant because clause 8 of the agreement is very clear. From the southern side, from his shop to the footpath.
So you want to say Mr. Mamadul is creating.
My lord, after the last order, my lord, my instruction is we have informed him, the tenant himself, that he please remove it. To that extent, we have gone. And in the writ petition.
One thing, been able to buy Bakalnama, so I was I'm carrying the Bakalnama with me.
The main writ petition.
As far as this issue is only document. For any further. Operating my, then I was forced to operate my shop from. I did a petition following the petition for the due procedure. Of this will allow him to respond. Till then, status quo is that petition. I made a specific. Don't make the paragraph.
because I'm operating. As well as pictures of the bamboo structure which I was operating with, those were also enclosed to the honorable court had passing an order of CITES.
But it was not cognizant of the fact that there was another writ petition where there was a.
It was, that order is, that order was also a part of the response. In my petition. I have a copy,
You have a copy.
That petition can go.
Which petition?
The file got a petition, I haven't done the file got your lordship has my. The file got a petition, into Amar. Your lordship has.
Who is, just a minute. Who is Aminul Alam?
Yes. I mean, our.
Baljit Singh?
Wait a minute, the tenant
Inderjit
under.
Inderjit Singh and Baljit Singh are?
The petition is there.
You are respondents here in this writ petition.
We were never served any
Notice
copy.
was not issued.
On the first day itself.
First day.
Second day on the instructions of the PMC that.
Then this needs to,
Even
then
we
this
were also
order
not
has to be reviewed.
No, Lordship. That order.
Sir,
No, Milord, that notice was never served upon us, so we are not aware of the developments in that case.
that is what.
We also did not appear in
Let
that
me
case.
make one submission, Milord. Let us not take resort to all these technicalities. End of the day, Milord, the photo do not tell lie.
Now,
Now, Milord, there is a direction from this honorable court that southern side or the corridor side, you have to clear it. But they have not done it. We are on this contempt proceeding, Milord. We are not on the,
That-
lordship is not deciding a civil suit.
that is what
Yes.
that is what I was trying to
Yes,
find out.
yes.
Contempt would be when it.
A willful, deliberate and willful violation.
He says he wants to clear it. He has a status quo order.
No, no. As far as Milord, the landlord is concerned,
Uh.
now today they are taking us, today for the first time, they are taking a stand. They have become wiser because of your lordship's order dated 13/10/25, which is in so many words, it was a very stern order. Kindly see, Milord. Para 3. Accordingly, on his prayer, list this matter again on 7th of November, so that he may apprise this court whether the circumstances as evidence in the photograph placed before this court by the learned counsel for the petitioner still exists. So he was cornered, Milord. So therefore today he has become wiser. Now he is saying, I have asked my Muhammadullah to, clear the path. Now my learned friend Mr. Pathak is appearing for him. Now he is taking the plea that in his petition there is an order of status quo. Milord, if he is so, he has taken cognizance of that order, why is he not taking cognizance of the order passed in my proceeding? Is it the requirement of law that you will follow your order, you will not follow the order passed in the other case? Well, at the end of the day, it's a question of maintaining the majesty of this law, court, Milord. Kindly see the order passed, kindly have the contempt petition, Milord, page 17. What is the order of this honorable court?
Order passed on.
Milord, order was passed on 18/12/24. In the contempt petition, the order starts at page 10. And if your lordship would kindly come to para 17, page 17, last para. Respondents number 3 and 4 will ensure the removal of the obstruction on the eastern side and ensuring entry and exit through the southern side within 3 days from today without affecting the kiosk of the Muhammad Alam. Now, my lord, as far as the last part is concerned, the GMC has removed it. Now, my lord, what is the stand of respondent number 3 and 4? That in the agreement, there is a provision that the space in front on the southern side can be used by them.
This is considered.
After considering everything, this order was passed.
This was considered.
Now, kindly see, my lord, please come to page 16. That's why I'm showing, my lord. Kindly see there, my lord, conduct, para 11. Sorry. Now, kindly come to para 9, page 15. As discussed above, the tenancy agreement as well as a copy of the plan, which are available before the court, do not in any way reflect the particulars regarding
ingress and egress of the tenanted premises, which has been rented out by respondent number 3 and 4 to the writ petitioner. The photographs which are available in the pleadings, both accompanying the writ petition as well as the affidavit in opposition filed by respondent number 3 and 4, shows iron shutters on two sides of the tenanted premises, and which according to the parties are the eastern and the southern side of the tenanted premises. The presence of shutters indicates that there is a permanent blocking in both directions. However, in the tenanted premises, entry and exits can be effective through eastern and southern sides or from both sides. Privacy from the materials available, this court is of the considered view that entry and exit to the tenanted premises of the writ petitioner must be permitted by respondent number 3 and 4 as the owners during the currency of the tenancy agreement executed by and between the petitioners and the respondent number 3 and 4, subject to such orders as may be passed by the competent court of law. No such order is placed before the court which injuncts the present petitioners from claiming entry or exit to the tenanted premises through eastern or southern or both. Under the circumstances, respondents number 3 and 4 cannot prevent petitioner for carrying on their business, and by preventing them from entering the tenanted shop premises from either the eastern or southern side or both, the claim of the petitioners that eastern side is blocked by erecting brick wall by the owner is denied by respondents number 3 and 4, submitting that the brick wall is in fact erected by the petitioners both on outside as well as inside of the shuttered area on the eastern side, projecting that it is respondent number 3 and 4 as owners who are preventing entry and exit into the shop premises. If that be so, then respondents number 3 and 4 will ensure that brick wall is brought down immediately so that entry and exit to the tenanted premises from eastern side is not hindered, and there is a free passage for the petitioners and other persons into and out of the tenanted premises. Insofar as the kiosk stated to have been erected by one Muhammad Alam, pursuant to agreement executed by and between respondent number 3 and 4 is concerned, and which it is stated that the said person is operating under a valid trade license issued by GMC, since the said person is not a party in the present proceeding, and removal of the kiosk without giving an opportunity of hearing to him will cause serious prejudice to him. Therefore, liberty is granted to the petitioner to file appropriate application for arraying him as a party if so advised. However, considering that tenancy agreement is still in force and the view that the discussions made herein above respondent number 3 and 4 will ensure there is no obstruction of entry and exit to the tenanted premises belonging to the petitioners from the southern side. In view of the order passed today, order of 17/12/24, more particularly direction at paragraph 8 of this said order stand modified to the extent that GMC authority will issue notice to Said Muhammad Alam, if not already issued, then thereafter upon due verification shall decide on the aspect of grant of trade license to such person to run the shop at the same premises where kiosk is permitted to be erected, and also examine whether there is any violation of the building bylaw rules under GMC and GMD authority by the said Muhammad Alam and respondents number 3 and 4 while executing the said tenanted lease agreement between them. If any such violation is noticed, appropriate action will be taken by GMC authorities under the provisions of. Well, apparently, respondent number 3 and 4 filed a suit for eviction against us. Now there is no injunction, no nothing. Therefore, my lord, they are doing certain things indirectly which they cannot do directly. My humble submission is lordships will not permit this. And even Muhammadullah Alam, he has also received notice from GMC.
You are appealing for, now in your writ petition, you have.
No,
made a
not in the
statement
contempt
that
petition.
in your writ petition, you had made an statement that the kiosk was already removed. If the kiosk was removed, the status quo is ordered, what does it stand for?
I had two statements. But the kiosk was after removal, was operating the kiosk from temporary bombs. Photographs of the structure, your lordship will also find at page number 58 along with the petition.
Iron frame part was never a part of the writ. It was your kiosk.
The iron frame.
Your
Kiosk was operating on
iron
iron
frame and
frame.
kiosk is same
How
thing.
big was it?
Very big, your lordship.
But is there in the petition?
One more interference and we will refuse you audience. Excitement has to be kept in bounds.
Lordship has my petition. Original pictures of the kiosk are also there. Petition. Or was removed. Lordship has page number 54, my petition.
Visible.
54, that brown, where it says Alam Traders, your lordship.
Huh?
That was the kiosk.
So that was blocking the gate of the petitioner's hearing.
On the
Was it-
southern
was it-
side.
Was it blocking the entire?
Yes.
As per the agreement that I have with the tenant, with the landlord, was where I was granted the this corporate business. I believe that the petitioner, lordship, what I have been instructed as another point of entry.
But you were blocking the one of the entries to the premises.
Perhaps there must be a passage.
Now
behind.
your stand is that it was blocked by an iron frame which you are calling a kiosk.
Yes.
Blocking an entire shutter, is it a kiosk?
That kiosk, because the GMC, if your lordship has the notice,
Let us not play with words.
there was a kiosk, your lordship, with an iron frame.
A small iron frame. I remember seeing something.
That was completely taken over and taken away and removed by the days.
So what the court ordered, what the court had ordered in the in your writ petition was,
Affidavit?
or in their writ petition rather was, that the kiosk will not be disturbed.
Kiosk will not be
You came up with a writ petition saying my kiosk has been taken away.
taken.
So whatever business you were running as on that date, instead of that small kiosk, was a status quo which was granted by the court.
In my case, your lordship, my case, I believe if your lordship has page number,
They're trying to see, yes.
page number 58.
Uh,
That is the kiosk which after that iron frame was taken.
After dismantling,
After
we are saying that on the date on which an order was passed in
Yes.
that case, it was a matter of one kiosk. There was one kiosk.
One.
And that was required not to be disturbed without giving a notice. That was required not to be disturbed without giving you a notice.
My understanding of the matter, your lordship, when the order was passed in this writ, that iron frame existed. So this order which was passed, your lordship has the order which was passed in this writ. Because
In
the iron frame existed.
insofar as the kiosk stated to have been erected by Mahmudul Islam.
Yes.
Kiosk.
Kiosk.
We understand the kiosk to be a kiosk.
So on the day the order was passed in this proceeding, iron frame existed.
Kiosk existed.
Kiosk existed. And with the iron frame, why I am using the word iron frame is, then after that on 18/3/2025 at 11:45 PM, the GMC removed the iron frame. After that, I was operating my shop from the bamboo structure. In that situation, I filed my on which date the bamboo structure was existing.
Let us again try to understand. You had a kiosk. You say you also had an iron frame.
Kiosk consisted of
kiosk. So
kiosk
your
and iron frame were
agreement
same.
with the landlord was for a kiosk. Along with it, you put up an iron frame. Court says kiosk not to be disturbed.
Kiosk not to be disturbed.
TMC removes the iron frame.
GMC removes the iron.
You come before this court in another writ petition, where you make this order, where you annex this order also saying that my kiosk was not required to be disturbed, but the GMC have done it. Now I am doing it from iron frames.
No, bamboo.
Bamboo frame.
Bamboo frames. Now I am doing it from bamboo frames. Court says, don't disturb him without giving him a notice. Status quo, whatever you've removed, now don't further do it. So your stand is that the bamboo frame will remain because of the status quo order. Your agreement with the landlord was never for a bamboo frame or an iron frame.
My agreement with the, not your lordship,
Was for a kiosk.
kiosk and
And where is it?
it is a part of this
It says that there is a bamboo, there will be iron frame covering the entrance and exit. Yes, show us. Show us.
Direct them to furniture.
Your writ petition, I'm looking at your writ petition. Show us that there was an iron frame. What were you supposed to put up?
Document 5, page number 24 of my petition. The schedule is there. 24 of my petition.
Hmm.
The agreement between me and the landlord.
Hmm.
Schedule is there.
Yes.
Iron structured shop room measuring 30 square feet situated at so and.
Where is your room, shop room?
SS Road, Nagpur.
He is renting out the road.
This is the, your occupancy covered by patta number so and so. No?
Is
I
where?
have GMC trade license also. Your Lordship.
Iron structured shop room. Where is that shop room?
That iron structure was taken away by the GMC, Your Lordship. That was my case before the coordinate bench. That iron structure was removed. Oh, there was a protection granted to me. That iron structure was
Your entire writ petition was on the ground that it was a kiosk.
kiosk and the iron structure are the same thing. Lordship as the schedule it says.
I remember some other kiosk.
Same.
Same. There is only one kiosk consisting of an iron frame. The frame was possibly.
They're trying to find out whether there is a contempt or not. Finding there is a contempt, that there is a willful deliberate way of circumventing the orders.
Yes.
Just not being able to.
Can I just come in for clarification of a fact, Miller? If your lordship would kindly take the affidavit filed by respondent number 3 and 4, please come to page number 89, Miller. And your lordship has very rightly appreciated that what is sought to be now described as a tenancy is the road between the shop and the Miller Road on the southern side. Please come to para 8. There,
3 and 4.
page 89, Miller, of the affidavit in opposition, filed by respondents number 3 and 4 in our writ petition.
Was filed by respondent 1 and 2.
No, 3 and 4, Miller.
3 and 4.
Yes.
There was another picture which was not a part of the record. This is the kiosk stroke iron frame or whatnot. This is as it existed.
I don't find any affidavit of 3 and 4.
In the WPC number 6119 of 24.
I was in this. Picture 2. Picture 2. What is this? What is this photo?
After removal, it was kept in front of the GMC office. My client went and took a photo of his kiosk. It was ordered to be preserved. We took a picture so that.
Yes. Your lordship got the affidavit. Now from here, my lord, the
Page number 80.
page number 89 is part of the affidavit filed by respondents in number 3 and 4. Now, this is the clause 8 of the tenancy agreement between petitioner and respondent number 3 and 4. Now, they are relying on that to show that the existence of kiosk has legitimacy. That the space between the footpaths and the shop premises will remain under the exclusive ownership of the first party, and second party cannot use this space in any way or manner as the likes or cause inconvenience to other tenants of the building. As the lordship got it, Miller. Now please come to the next para. That is the quotation of that agreement. Now please come to their averment. Same was incorporated with a view to utilize the space between the footpath and the shop premises for another commercial venture. As a matter of fact, one Muhammadul Alam was already allotted this space by an agreement dated 1/8/23 for installation of a kiosk-like structure for retailing purpose. All necessary permission, including a trade license, was also obtained from the respondent number 1 authorities in this regard. Am I clear, Miller? So the stand of the respondent number 3 and 4 is the space in between the footpath and the shop does not belong to the tenant. So the landlord can very well use this for any other commercial venture. So therefore, what he did, on 1/8/23, an agreement was entered into with Muhammadul Alam for that setting or letting that kiosk. Now, my lord will kindly take the writ petition for a moment. Kindly mark this date 1/8/23. Now, my lord, in the writ petition, we have given the photographs of the, my lord, situation status. Please come to page 70. Kindly see, as on 15/8/24, this was the position, my lord. There was no kiosk. Please come to the next page, my lord. 71. Then please come to page 72, 21/10/24. On that day, the kiosk is there. On 1/8/23, it was not there. So apparently, it's a false statement made on oath. 1/8/23. Yes. It is a false statement made on oath. If necessary, my lord, will take recourse to section 340 CRPC. Then, my lord, will kindly come to page number 73, 22. Every day they were improving, my lord. 22/10/24, this was the position. They are not only block. Kindly see now, this is a very ideal picture, my lord. Kindly see the space between the footpath and the shop. Hardly it will be about, my lord, 6-7 feet. Now they say they have a right to utilize it. And I am a tenant of the shop. Well, end of the day, there is something called rationality. Merely because a client has come to me, it's not that I will project, my lord, whatever the client says to the Honorable Court. We also should exercise our discretion. Then please come to page 74, my lord. 23/10, more or less the kiosk is complete. Then, my lord, will kindly come to page 75. Now this is the situation. Now one Alam Traders has come up. Kindly see, my lord, what is the gap between this kiosk and my shutter? Is it something which is acceptable in, my lord, in a modern society where, my lord, the rule of law prevails, where we all claim to be civilized citizens? Kindly see, my lord, what is the distance between this kiosk and is it not the way to, my lord, block my tenancy? Then please come to page 76. Even the corridor, my lord, the eastern side, that is also blocked. Then kindly, so these are
saying that in their affidavit, they are saying
that
you built that one.
That means an agreement was executed on 1/8/23 for installation of a kiosk.
That they have,
I'm sorry, my lord, I couldn't get you.
they have said that you have constructed the wall, if I'm not.
In the eastern side.
That is inside my premise.
That is inside my premises, my lord.
We have
No, my lord, the photographs are, my lord, reflective of the ground reality. Now, no, there is no point hiding from that.
Is Muhammadul a party in the repetition?
Yes.
Have you filed the?
It was allowed also. And
No,
they
no,
have
have you
received-
filed the
Amended cost
amended
package.
cost type?
Oh, itu naik orang ni.
You filed the amended cost title because he is making a statement that he would appear for the say, respondent.
Maybe it was
included,
left
but
out,
he
Miller.
is not being able to file the wakalatnama or any other document because the amended cost title is not there. He is not yet a party.
No, amended is not.
Very good, yeah.
The
We'll
prayer
take it
in the
tomorrow, Miller.
petition is for a direction to the GMC. Who appears for the GMC? Yes, sir. What is your stand in the matter? They are saying that the shop installed in front of the petitioner's shop just attached to the footpath, in the land between the footpath and the entrance. Another shop was allowed to be a shutter. Once, there are two shutters, front of one of the shutters and iron.
One side of the island is there.
Yes,
That's-
southern side.
That shop came up. Their stand is that that shop should go. To remove the kiosk. It was then subsequently it was modified to what? To remove.
1712 was an order where within 24 hours it was to be removed. 1812 is the next order, which Lordship.
The other petition came in
No,
saying
no.
that there is a.
1812 is the impugned order in the contempt petition.
Help me, Lord,
Oh, well.
there's some notices, a requirement of notice and all were envisaged.
Ambitious. 17 it was within 24 hours, but it was modified on 18.
সে তো পড়িলে তো এই মাত্র 1812 page 17 of the contempt petition it is mentioned.
So on 17th, there was an order, just remove it. On 18th, an order, give him a notice and then remove it.
Yes.
Remove it, but
And it was, but it was already removed on the 17th night. Yeah.
removed on 18th.
No, 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 no. No, 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 no.
Just mark of next year.
Subsequently.
2025.
This order of 1812, this 1812 notice was not in your, order was not in your notice. So I think we have to allow that.
Yes, yes,
amended
we'll-
post title.
That
Let him put in his thing. Order which has granted a status quo in his case. Effect of that order has to be considered on this writ petition.
Correct. Let
Because
them furnish
notice
us a
was not
copy, our copy decision.
Mm.
Oh, my lord, problem is that writ petition was disposed of without notice
This is
to
what.
us.
Even we were also not issued notice. First it petition, we were also not.
The issue was simple. There is a kiosk. Without notice, someone is trying to break it. Don't do it without issue.
That is why no notice was issued.
But the fact that it has already been removed, there is another writ petition pending. I did not.
Even Supreme
that
Court has said,
petition-
my lord, even post facto notice also can be given. Even otherwise.
As opposed to.
Order was passed on 18th December 2024.
Mr. Pathak,
Removal.
Only
Mr. Pathak, you see, when courts are passing orders, unless certain things are stressed and brought to the knowledge,
It is this part.
the straight line order. Which order? The order passed in your case. Where is that?
Page
Everybody has
55.
brought- Huh?
Page 55 of the, in the contempt case.
Contempt case. And the petition from the folks, although এই রিপিটিশন ফ্রম লিখিব হ্যাঁ দুইটাটা অর্ডার বেলেগ
Disposal to page 53 per ambulance.
Page 55.
Starts from page 53.
That's from 53. These all aspects were before the honorable court.
In fact, paragraph 5, my lord,
Your lord, as paragraph number 9,
It would be important.
that order passed in my matter, having regard to the.
How much time will you require to file your affidavit in opposition in this writ petition?
2 weeks.
We'll provide it today.
today, yes,
Okay.
yes, today.
I'll amend that.
Copies, provide you copies when?
Occupies paragraph number 9 of that petition, of that order.
This page 52 is your case.
Yes, page 50. Of the affidavit in opposition.
Compensation to, what are we-
Having regard to the observation made in paragraph 14 of the interim order dated 18/12/2024 passed in the writ petition. And considering the fact, so that order was taken cognizance of by the order which was passed in my writ petition, the court bench was aware of this process.
My lord, what would be the meaning of the, my lord, status quo having regard to para 5? Para 5 that ordered at page 55. The petitioner has approached this court by the instant writ petition alleging high-handed action on the part of the respondent GMC by stating that on 18/3/25 respondent GMC had carried out dismantling exercise whereby iron frame standing in front of the petitioner's tenanted premises has been dismantled and taken away without issuance. So, my lord, what court recorded was it was already dismantled on 18/3/25 and it was taken away. Therefore, to maintain status quo, where is the authority to build this bamboo structure? Well, they're cornered from all sides now. Whatever stand they take, it will boomerang.
Bamboo
Kindly
structure
see, my lord.
prior to this order.
How can they educate their princess? Let us not convert this proceeding to a farce.
The writ petition.
You can file a civil suit for this, claiming compensation.
Order dated 22/8/2025. Impediment of the respondent number 5 was allowed, and the counsel for the petitioner was required to file an amended cost item. The amended cost title is not on record, and petitioner is afforded 3 days time to file the amended cost title as required by the order dated 22/8/20. The counsel for the petitioner shall also ensure service of copies of this writ petition on the learned counsel appearing for on Mr. KP Pathak, learned counsel who has stated that he is under instructions to appear for the respondent number 5 and has stated that he would be filing his wakalatnama when the amended cost title reflects his claim. The other contesting parties in the writ petition will ensure that copies of pleadings filed by them is also supplied to the to the council appearing for the newly appointed respondent number 5 before the next date of listing. Whatever you have filed, you give copies, otherwise you'll come and say no. The petitioners, you have filed your reply to it? You have filed your reply to the affidavit, sir?
No.
The petitioner shall be at liberty to file reply to the affidavits filed by the respondents for the next date of listing, full stop. The respondent number 5 is afforded weeks time after being supplied a copy of the writ petition. File his GMC, Mr. Nayak, would you be filing affidavits?
I am party on writ petition, Lordship.
There is only one writ petition.
Lordship, in the contempt.
No, we are only on the writ petition now.
Lordship, writ petition.
6119.
We are affording him 2 weeks time, we are affording the same time to you. Mr. P. Nayak, council appearing for the GMC authorities shall also ensure that the stand of the respondents are brought on record before within a period of 2 weeks from today. Stop. List this matter again on.
Can you pray for 15, Miller?
January. On 17th of December 2025.
Yes.
By which time all parties shall ensure that the required pleadings are brought on record, full stop. An attempt would be made to
dispose of the matter.
Dispose of the writ petition on the next date fixed.
In the contempt petition, the writ petition they have filed, which was disposed of, will just file an additional fee to bring on record that writ petition. But that's not a part of the contempt.
The writ petition, in the contempt petition, you write. Heard Mr. Kencho. Das Lanet Commissioner. heard Mr. D. Muzumdar, Learned Counsel. Learned Senior Counsel assisted by Mr. D. Deca.
A Deca.
A. Deca. The counsel for the respondents. Respondent number 3 and 4 have filed their.
We have
Respondent
filed
number.
what?
Others. Respondents have filed their affidavits, which are on record. Full stop. The alleged violation of the orders passed by this court shall also be taken up for consideration, along with the writ petition on the next date fixed.
I'll be filing an additional affidavit that
The D. Muzumdar and its senior counsel prays for prays to be allowed to file additional affidavit, bring on record the writ petition filed by his tenant.
yes. WPC number
That is WPC number
1741 of 25. 1741.
Yes, on the next date, either it's contempt, it is not contempt.
You'll have
Try to take a
decide.
call.
Deeply. More ideas.
Item?
May it please your lordship. My lord, in this matter, I am challenging the demand raised by the EPFO, my lord. There has been a demand and penalty imposed upon me, and I am challenging that, my lord. My lord, what has happened in this matter is, I am a partnership firm, my lord, a registered partnership firm. I have purchased a property which was functioning as a hotel, namely Hotel Borel View in Silchar, my lord. After I purchased that property, I have started a new hotel, namely Masses Hotel Borel View Regency, my lord. It's both the entities are totally different and do not have any correlation with each other. The partners and the shareholders of the companies and everything are very different. PAN numbers are different. EPFO registered number are different. Now, my lord, what has happened is the EPFO authorities has raised a demand against the Hotel Borel View and stated that in the demand it is stated Hotel Borel View alias Hotel Borel View Regency, my lord. That is the entire case, my lord. The authorities were in a misconception that both the firms, there has been change in the name of the firm, and in their affidavit they have also mentioned that there has been change in the name of the firm.
This Borel View Regency
Yes,
is a what?
Is a hotel owned by me, my lord.
It is a partnership firm.
Yes, my lord. I have purchased the property from a private limited company, my lord.
Registration of your partnership?
Yes, my lord. I have annexed my partnership deed. It is not disputed, my lord.
Where is the partnership registration of the partnership firm?
My lord, I have not annexed the registration. I have just annexed the
Do
partnership.
you have a registration of the partnership?
Yes, my lord. That is there.
Where is the statement?
Para number 11, my lord. Para number 11.
Para number 11.
11 of the writ.
Page number 15, my lord.
You are for Borel View Regency.
Yes, ma'am. My lords, may kindly look upon the impugned demand, my lord. At page 45.
We'd first like to see the registration certificate of the registration under the Partnership Act.
My lord. Yes, my lord. My lord, the PAN numbers are been mentioned, my lord, and the PAN numbers are also.
Partnership Act conduction. Take up the matter at 2 if required. First that before we proceed. You have that? No issues. We'll proceed with deciding.
My lord, they have not disputed, my
Not
learned.
necessary for the court to decide.
Apologies, my lord. I'll annex that, my lord. I do not, I have not annexed
You
it.
will not require to annex it.
But if I may apprise, my lord. They have already
made a party to the Boral View and they were supposed to appear today.
Did just receive. So I would be.
Allow everything. Hey, come on. Huh? iPad 20. If it is out 169 in partnership. Oh, you must be having a mobile. Ah. Stood. Agor ke stood. Very good. KP Pathak.
Yes, my lord.
What is it?
If I may read, my lord. Effect of non-registration. No suit to enforce a right arising from a contract or conferred by this act shall be instituted in any court by or on behalf of any person suing as a partner in a firm against the firm or any person alleged to be or have been a partner in the firm unless the firm is registered and the person suing is or has been shown in the register of firms as a partner in the firm. No suit to enforce a right arising from a contract shall be instituted in any court by or on behalf of a firm against any third party unless the firm is registered and the person suing are or have been shown in the register of firms as a partners in the firm. Subsection 3, my lord, the provision of subsection 1 and 2 shall apply also to a claim of set off.
That will do.
Yes, ma'am.
And 1.
Yes, my lord.
That is what we are asking.
My lord, I am a
Registration of the deed does not suffice. PAN number does not suffice. All your agreements with anybody does not suffice. Firm exists, can be sued, but cannot sue. You cannot approach a court of law if your firm is not
registered.
All your deeds registration, all your GSTs, all your everything. This something which is not, even if they are not taking up the ground, I have to look into whether it is.
Absolutely, my lord. Absolutely.
Registration of the deed is not going to do the job. Want it at 2 o'clock or you want it on a later date to find out whether the firm is registered?
My lord.
Society's registration, have you heard?
Yes, ma'am.
All those flats, all the societies have to be registered. Same office. Also the register of firms.
Yes.
Unless registered, we would not like to.
My lord, though I am a registered firm, I have not annexed the document, my lord, appropriate document proving. My lord, if I may take instruction upon this, if the matter can be taken up at 2.
Yes. No. Eta matter baki ase abhi.
Deeply obliged, madam.
Find out the registration if it is there.
Yes.
You have to bring on record, record the same before you proceed. If it is not there, then we'll have to close the matter today.
Then in that case, my lord, may kindly adjourn this matter and fix it on, my lord, 2nd week of December, my lord, any date.
At the prayer for the learned counsel for the petitioner.
Yes, my lord.
No, heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard Mr. So-and-so learned counsel appearing for the
PFO.
Huh?
Respondent number
PFO.
D go back for respondent number 3, lordship.
For the newly imputed respondent number
5.
5. Who, full stop. The learned counsel for the respondent number 5 prays for some time to file the affidavit in response to the contentions raised in the writ petition. Other respondents have filed their affidavit.
Yes, your lordship.
Petitioner, you will file any reply to that?
My lord, I have
To the
filed.
affidavits?
I have filed the reply.
Petitioner has also filed replies to the filed by the other. Is this matter again after 2 weeks, allowing the respondent number 5 to have to file their response in the matter. So,
My lord, can this matter be listed on 11 December? I have an interim prayer, my lord, in this petition, my lord. I'm seeking for an interim relief.
What are they doing? They're
My
recovering
lord,
against.
47 lakh rupees has been freezed in my bank account. My lord, I am ready to give an indemnity bond until the disposal of the writ petition, my lord. There has been non-compliance of principle of natural justice, my lord. My lord, there is a.
How can you freeze the accounts, bank account? How can you freeze bank accounts?
my
Who
lord,
has
this-
frozen the bank account?
Yes,
Lord-
my lord, in this case, if I may, they have been informed earlier regarding while they have been transacting with them, their dues were left out from the earlier part. And the EPFO, they are using the same employer and they're using the same employees in their and the same structure. And as per the act, my lord,
Whether they are liable to pay you or not is one part. Whether you have authority to freeze their bank account is another part. There is that authority to seize bank account, to freeze bank accounts. Is there any authority?
yes, my lord.
Please. PFO.
My lord, in this case, when
Which section? PFO condition?
kindly look into section 17B. 17B, my lord.
What does it say?
17B.
What does it say?
A liability in case of transfer of establishment.
Hmm.
My lord, may I read?
The account freezing part. We are not on any other liability. You can freeze their accounts, take their movable and immovable properties into your capture.
No, my lord, we have given them
Yes.
this abundance of time. My lord, let's.
Your right to recover, we are not questioning. But what is it called? For international relations, it is called economic sanctions. Stop a bank account. How, from where do you do it? Place this matter again on 11th of December 2025. The Learned Counsel for the petitioner has made a suggestion that the bank accounts of the petitioner firm has been frozen by
EPFO. Respondent two.
you don't maintain a bank account with
Sorry,
the
By respondent number three, Lordship.
Punjab National Bank.
By the
EPFO.
Punjab
in
National
direction to the
Bank.
PNB.
at the request of the EPFO.
Yes,
full stop.
Lordship.
The EPFO and the Punjab National Bank
Lordship.
shall form this court on the next date fixed. The provisions of law under which bank accounts have been chosen of the petitioner.
Lordship.
We are not allowing the freezing accounts. It is as well as asking him to get out of the house and staying in his house.
We have issued lots of notice.
All you have done, do you have the authority to enter into his account?
Lordship, we have freezed the account, put lien on the account, in compliance of order passed by the respondent number two.
So tomorrow some other person says that he
Even after that,
this man
Lord-
owes him money.
They have issued so cause notice against
They
me.
have, if someone says someone tells you that so and so has passed an order against so and so,
Lordship.
you'll keep the money with you. Can you? Freeze
No,
accounts?
Lordship.
Can you freeze accounts unless there is forgery or fraud or a request by the account holder? You're only a person maintaining an account unless there's an order from the court. Can you
Lordship.
freeze accounts? Or in some other cases, money laundering cases, some cases where there are appropriate provisions of law to freeze accounts.
Lordship.
Does the EPFI have the authority to freeze, to request you to freeze accounts?
They have passed an order, Lordship.
Indeed, that is what I'm.
Number 134, my lord.
This one,
Yes, my lord, in this only, section 8F,
8F of?
EPFO Miscellaneous Provision Funds Act of 1952, 8F, subclause 3X.
What does it say?
Other modes of recovery.
What is your demand?
45 lakhs.
The amount in your bank?
70 lakhs was there, my lord. Initially, they freezed it. The honorable court has granted interim relief that only to the extent of 47 lakh may be kept, and the remaining of my interim prayer in regard to indemnity bond will be considered at a later stage.
Say that it is money on account of the employer.
Eight F subclause 3, Roman 10, my lord.
Four.
Roman 10 also. Roman 10.
And
is
also,
also there.
eight, four, 8F4.
8F, subclause 3, Roman 10, my lord.
1-4. 8F
Subclause 3,
plus 3, Roman
Roman
4.
10.
Have a look
10
at
is also
4.
applicable, my lord, here.
Save otherwise, every person whom a notice is issued shall be bound to comply with such notice, and in particular, when any such notice is post office, bank or insurer.
Yeah, it regards
Thank
to
you.
that, he fails to make the payment in that
Hmm?
case, my lord. He fails to make the payment.
He has failed.
Yes, he has failed, my lord. That is the reason.
Yes, it is.
My lord, the demand of the dues pertains
Merits,
to previous.
your merits after you bring on record your registration.
Yes, my lord, I'll do that. My lord.
Registration of the deed is not enough. Registration of the firm has to be there.
Yes. I'll satisfy me. My lord, if the interim prayer may be considered in the next.
The interim prayer shall be considered on the next,
11
on the next case.
Fixing a date
11th,
subject to the availability of the other councils can be had on 12th or not.
12th,
12th.
12th, my lord.
12th of December.
Yes. And deeply obliged.
Yes, dear.
তুমি কি বলে গেছে এফেলে হ্যাঁ
There are two IMs. In one IM, my senior is the applicant for applicant and the connected I am for the applicant.
Let the senior start.
Melota, we filed the Melota IA for Melota start down the Melota petition number 3. In IA number Melota 377. Or start out the petition number 3.
Proceed party number 1 is petition number 3.
Melota.
He does not want to pursue the matter.
Yes, Melota. She wrote a letter to me, Melota, that is Melota page 12.
Nuruddin Ahmed,
No, Melota. Minara Khatun.
Minera Khatun.
Minara Khatun.
He was the original
Number?
petitioner number 3.
3. She Melota does not want to Melota continue as the petition number 3. So Melota I filed the Melota I for start out her name.
Yes, any objection?
No, in the same IM, my lord, the same applicant, my lord, the same petitioner is the applicant here in this IM, my lord, in the connected IM, my lord. The IA that has been filed by me in the connected IA, the petition number 3 is the applicant here. In this IM, my lord. In the connected IA, subsequent IM.
Both IAs with the same prayer that I should be not.
No,
I do not want
here,
to.
my lord, the prayer is slightly different. Here,
What?
the case of the applicant is there, my lord. Writ petition was filed challenging the election of the president and vice president of the Anchalik Panchayat. Here, the present applicant is the one of the member of the Anchalik Panchayat. Writ petition was filed showing the name of total 5 writ petitioner, my lord. Now, the case of the applicant is that while filing of the writ petition, when the applicant was not informed that a writ petition was filed in her name, she did not sign any papers relating to any writ petitions or wakalatama. Now, the question of the applicant is that how the writ petition could be filed without her consent or without her without being a signatory to the decision. That is the case of the applicant. Ma'am. The applicants was that the other four writ petitioners, they have been added as opposite party in my IA. Then either my signature was forced. Obviously, without my signature of a petitioner, my writ petition cannot be filed or no application can be filed. Now, the case of the applicant here, that writ petition was filed in her name without her consent or without being a signatory to the writ petition. Obviously, my clear is also to withdraw my part from the writ petition. Here also, I am seeking the same relief that I may be allowed to withdraw my name from the writ petition, and at the same time, my signature was forced, my lord. Writ petition was filed without showing me as a petitioner, but without my consent, my lord. That is a very serious.
Here, what is the
My prayer is that, my lord, at least show cause notice be issued to the other, the opposite parties here. There are total 4 opposite parties, my lord. Those 4 opposite parties are the writ petitioner, my lord. So I'm not pinpointing to any one of the writ petitioner. There are total 5 writ petition, including.
So now we
My contention is that.
and cause an inquiry.
Yes, sir.
Will cause an inquiry.
Yes, sir.
Who will inquire?
Well, your lordship will make the inquiry as to who actually.
Inquire.
Personal appearance of all the writ petition will be directed so that the matter will come out clear.
Possible, Mr.
I got the one copy of the application regarding my link striking off. The other what my learned friend is my lord.
That my signature first.
Force matter that my lord. It's a very serious serious issue.
The appropriate.
Appropriate my lord. If your lordship under 226 can also.
Who alleges the forgery?
He alleged that his
Takes a record.
saying that my lord, Wakalatnama and then has not been her signature. And without her consent and without her signature, a writ petition has been filed. If you see in that way also, my lord, the other side, the advocates of the other side also will be in trouble, my lord.
So then we cannot allow the striking out. Because they will say that we did not sign it, she had signed it herself.
Yes.
They'll file an affidavit.
But
they may file an affidavit saying that no, it is not my signature, please. Terminate it. Down here and do it.
Yes, yes. In that case, my lord. But in this striking off, she has sworn affidavit. And most probably on the writ petition only with regard to the signature made in the Wakalatnama.
The repetition.
This is not the writ petition for one. She has filed this.
Oh, acha.
Striking me out.
Oh, my lord, my lord, my lord.
Yes.
Yes. She has not filed an affidavit, Minara Khatun, my lord. So it cannot be
No,
allowed.
it can be. The Wakalatnama has to contain her signature.
Yes.
Wakalatnama khan kotese. Petitioner, it থাকে না এটা। কোন ফেলে থাকে Wakalatnama khan?
Rifa Julka, my lord, this is a petitioner number 1. It was
Khurshida Begum. Who is Khurshida Begum? Respondent.
yes, madam. No, Rifika Julfa is the petitioner number 1. Rifa Julka, my lord.
Khurshida.
This 3840 IAS has been sworn by my lord. Minara Khatun, the one who alleged that her signature is fraud. But
We are trying to find.
striking off was affidavit was sworn on by my lord, petitioner number 1. So again, it might. Writ petition, my lord, affidavit sworn by Rifa Julka, my lord. That is petitioner number 1. Striking of same, my lord. Rifa Julka.
That is one you are referring to.
And 3840, it was by Minara Khatun. And your lordship is very much right, my lord. After sometimes I can see my come and say that this, I have not allowed or I have not authorized her since the affidavit has been shown on by the.
Yes, Mr.
Rifa
Qayyum,
Julka.
My lord,
you say about this allegation? The other IA has been served upon you.
yes, I, my lord,
There are 4 signatures here. 5 signatures.
I think Mr. Smith.
Rifa Julka, Rabiul Islam,
No, my lord,
Nuruddin
that is my
Ahmed,
lord,
Minara
Rifa Julka,
Khatun, and
Rubul
Sakura Khatun.
Islam, Benara Khatun, she is the my lord, petition number 3.
And the signatures do not appear to tally on the Wakalatnama and the
But my lord, she wrote a letter to me, my lord, that is at page, my lord, 25. In IA number, my lord, 3777.
three triple seven.
Yes, my lord.
Letter.
Page 12, my lord. Lordship, my lord, kindly peruse, my lord, there are 2 signatures, my lord. One is my lord, Minara Khatun, and left side, she signed before me.
Huh?
There are 2 signatures, Minara Khatun, my lord, that is my lord, yours faithfully, then my lord, Minara Khatun, and my lord, then left side, there is another signature. And this signature was put in front of me, my lord, because I have some doubt that why she is, my lord, wants to, my lord, withdraw from the writ petition. So, my lord, I told her that you should sign in, my lord, before me.
Now, this signature does not match with the one which is there in the Wakalatnama.
Maybe, my lord.
It
Yes.
does not match.
Yes, yes, yes.
So let us, we will not.
But since my lord, yeah, she does not want to, my lord,
No, since the allegation by the
It is
submission made by the learned counsel is that.
it is subsequent allegation, my lord, but
No, we
before
can-
me, my lord, he wrote a letter on 1710. It is on 1710, my lord, page 12.
But my lord, affidavit is by Rifa Julka, not by the.
You are not understanding it.
I got it.
The issue is,
No, my
we
lord,
would have
my lord, I'm.
allowed the petitioner to withdraw.
Yes,
Strike her out.
yes,
Matter would have settled.
yes,
Now, the learned counsel wants that an inquiry should be conducted.
yes, that's why, my lord, I am.
That why a false signature was made.
Yes, my lord.
And Mr. Qayyum is saying that the lady had appeared before him
Yes.
Yes, my lord.
to put her signature, saying that I want to withdraw my name as the petitioner as I am not interested to continue as the petitioner number 3.
But in the.
Meaning thereby that originally she was interested in
Yes.
being the petitioner number
And then
3.
put her signature.
As of now,
She
she
is
is not interested.
interested.
She must have told someone, "I put my signature." Someone put her signature, and now she's doing a.
Yes.
She's going back.
Yes.
Saying that we'll put you in trouble now. Why my
Lordship knows, my lord, that it is, my lord, every time it is the, my lord, number games. Number games. Election
Yes,
of.
Minara Khatun, can she come to the court
Yes, madam.
to clarify whether this letter was written by her
Yes.
or whether the
So far, my,
IA prayer is by her?
so far my instruction is concerned, my lord. After she coming to know that a writ petition was filed in her name, obviously, my lord, she approached the counsel of the petitioners and requested them to withdraw her name. This part is correct. So I'm not denying it, as per my instruction of the applicant. Subsequently, again, the applicant wants that how the writ petition could be filed without.
It is after thought.
After, obviously, it is after thought. Firstly, after coming to know that writ petition was filed in my name, without knowing my knowledge, I approached them and requested them to do my name. This part is correct. I admit it. But the question is how the writ petition could be filed. That is the question.
As I am not interested to continue as petitioner number 3. Continue it.
This part is correct, ma'am.
Was started
means-
with her
Yes.
consent.
Yes.
Yes, ma'am.
Now she is changing her.
No,
And she says that it is not my signature. Let us put them into some.
no,
trouble.
my lord, I have
Sit
not
down.
copy of the IAM. my
Heard Mr. D.A. Qayyum, Learned Counsel appearing for the applicant in in IA civil number 377 of 2025. Passed in WPC number 4272 of 20.
মোৰ আগতে হৈ লিখিছে
Applicants
কথা
in this IA are the writ petition are four of the writ petitioners in the original writ petition and who have submitted that the petitioner number 3 in the writ petition has expressed her unwillingness to continue with to continue to pursue the present writ petition. Interlocutory application is supported by a letter dated 17/10/2025 issued to the Learned Council appearing for the writ petitioners, where the opposite party number 1, who was the original writ petitioner number 3, has stated that has made a request to withdraw her name as petitioner number 3, as she is not interested to continue as party as petitioner. Mr. D.A. Kayum, Learned Council has assured this court that the signatures appearing on the said annexure are the signatures of the petitioner number 3 signed in his presence.
Yes, ma'am.
Another IA number 38402025 has been preferred by the writ petitioner number 3, wherein a prayer has been made not only to strike out and not only to be allowed to withdraw her name as the petitioner number 3, but also issue notice to the opposite parties, namely the writ petitioners in the original writ petition, as to why necessary action shall not be taken for forging signature of the applicant while filing the writ petition. One prayer common to both the interlocutory application is allowing the petitioner number 3 to withdraw from the writ petition. Which in ordinary course would have been allowed by this court. However, there are allegations of forgery being imputed upon by the petitioner number 3 upon the other writ petition. Therefore, no, you wrote that sentence, no? Ordinarily, this allowed the petition number 3 to withdraw herself from the writ petition, and the matter would have rested thus. However, there are allegations have been imputed by the petition number 3 on the other writ petition. In such view of the matter, this court allows the prayer of the petitioner number 3 withdraw herself from pursuing this writ petition. Liberty shall, however, remain with the petitioner public applicant in 38 IA Civil 3840 of 2025 to pursue her such remedies for redressal of her grievances, if any, regarding the allegations of forgery of her signatures while filing the stop. Interlocutory applications are disposed of. You follow your own.
We have to file an amended post title.
Now come to the repetition. By an order passed today in the IA Civil number 3840 of 2025 and 387 of 2. Petitioner number 3 has been allowed to withdraw herself from the array of petition. Accordingly, Counsel for the hearing for the other petitioner shall now file an amended cause title before the registry within a period of 3 days. Okay. Is the matter thereafter?
Yes, my lord. Already the matter fixed on 12/12, my lord. In the repetition, it is fixed on 12/12.
Is the matter again on 12/25, comma, a date which you earlier fixed?
Yes.
Earlier order.
Yes.
Don't bring this.
No issue. My prayer is also same, my lord, for to withdraw my name from the writ petition.
A petitioner may have so many grievances. They are here sitting in the High Court trying to solve out a legal problem. You bring this dirty linen into the court. That's not good. Then if I
We have,
have
we
them
have
con-
faced, my lord, many
That's a
problems.
different issue. Asking us to conduct an inquiry, oh, this signature is false, that's, you don't know in which writ petition, which statement will be found to be false. Records, false. Knowledge, false. This not supported by records. We'll be sending everyone to for an inquiry and investigation, reduced to a.
My lord, what happens normally? No issue.
You don't want to proceed with it, just simply say we don't want to proceed with it. We have also lodged an FIR. That is enough for us.
Yes, yes.
Yeah.
Yep.
Publish.
Itu bisa pemain.
Rule number 289, my lords.
Huh?
Rule number 289 of excise.
Number 289.
Excise rules.
Yes.
Clearly spells out who can file complaint, who cannot.
And?
The radius of the complainant is periphery is bind here.
And? Are you required, they are within that periphery or they are not? Let us have it. Yes, sir. He's talking of some boundaries and peripheries.
No, that has been complied with, and accordingly, my lord, this sanction was
We need to
granted.
see whether the complaints on which they are trying to act,
Yes.
whether they have been given by persons who are entitled to.
Whether they are in, they have any locus.
Only that, only that much. If it is so, if they are within that area, then the complaints have to be taken into account.
Yes.
And if they are not within the area,
That your lordship will get it at page 61. Page 61 of their affidavit.
200 public place of worship.
On the basis of this, the affidavit has been filed. Paragraph 7, page 59, my lord.
Of the writ petition.
No, yes, of the.
Just give me 1 minute, sir. I'm trying to go through that manual exercise rule.
আসলে দুর্বস্তি কৰিছে এনেকে নহয় নহয় কোনোবাই নাখায় নাখায় আৰু কোনোবাই খায় খায়
You are referring to 289.
Merits.
Say that it should not be within 50 meters or 100 meters or 150 meters from a place of public worship. That is not the issue here.
Or educational institution.
Educational institution. It is not within the 150 meters of an educational institution. If it is not, we can then 50 and 100 will automatically go.
And we'll leave to the conscience of the people surrounding. If they want to drink, they can come. That's all right. Yes, ma'am. Because what is morally might correct, but legally it's, I don't think there's a ground.
There is a story about morally and legally correct. Do you know that? When a professor asks what is legal, 80-year-old marrying an 18-year-old, legal. May not be moral.
But
Yes, sir.
I feel.
They are almost admitting that.
No,
the
yeah,
educational
I'll just
institutions
help
are-
your, assist your lordship with one or two judgments. Please, I think that I've given one C, like C, your lordship will kindly see.
Like C?
Amlan.
Amlan. That my learned friend, this was a petition filed by the delegates of the ASU for cancellation of the inquiry report. Then the findings of the court is this, my lord. Your paragraph 2, your lordship will kindly see. The petitioners, may I just read one? Paragraph 2. The petitioners have prayed for setting aside the impugn inquiry report. They are delegates of the All Assam Students Union. Report dated so and so issued by the respondent number 4, which basically states that the proposed Indian so and so on shop does not violate rule 294 and 295 of the excise rules. The petitioner's case in brief is that the petitioners are delegates of All Assam Students Union representing the so and so. The petitioners agree by the impugn inquiry report dated so and so as the Amgori Girls High School is opposite to the proposed IMFL on shop. Paragraph 3, my lord, the petitioner's counsel submits that the rules so and so rules empowers the local people to raise objections against the against allotment of liquors license in their residential area.
In the end, it is said that they do not reside within 75 meters and therefore
so
their
they do not have locals.
objections will not be taken, will not be given any.
Because they do not have locals. It says so. There are
In your
30
case,
paragraph 30.
they say that there are some complaints made by the university and all.
No, only assume it.
Only ASU, and therefore we are not doing it.
Therefore, they are saying it is.
But, we can then we'll have to say that that cannot restrain you.
Yes.
Such objections will not restrain you, and the due process of law has to be followed.
Subject to satisfaction subject to fulfill other statutory prescriptions.
Have you taken a stand that some other statutory
That
prescription is not
liberty may
followed?
be there, my lords.
Huh?
Liberty
That
may be there.
stand is
That-
there
that
only-
much may be given.
Only stand is that letter, madam.
That must be given, my lords. Because I gave the judgment to Vice Leonard Singh in this case.
Because
Give and take.
because of that, my lord.
Give a
Another
judgment
two,
and you give us the liberty.
another two judgments I have given that public sentiments, paragraph flag A and B. I think the note has been also given. Note is also there, my lord. The public sentiment cannot be a reason for deflecting the law, my lord. I'll just read the note. Public authorities obliged to act fairly and surely not whimsical. Cannot cancel license on grounds which are not contemplated under the Act. Pertinent to note that the grant of license under the Act and rules framed thereunder is not subject to public sentiment. And the second case, flag B is, my lord, renewal was
They
not
were, they
recommended.
were required to take a reasoned decision, but in
Yes.
your case, I think we can say that the objection which has been filed before them does not require a
Yes.
consideration.
Only your
Therefore,
lordship,
the process for giving
process
you
for
the license
license has to be given
shall
as
be-
per rule,
shall be taken up
as
as per
per
rule-
rule 116.
as per
Rule
Rule
116.
116.
They have accepted rupees 10 lakhs towards fees and all. Government has accepted.
So we'll say they will process it in accordance with law
So as per rule 116.
without taking this as a impediment to the process.
Within a stipulated time.
Yes, the outcome to be made known.
And fulfillment of other any statutory prescriptions. my lords. That line.
Nothing is there in the affidavit, my lord. Why he is saying something?
Okay, we come back
not
at,
there?
My lords.
we'll dictate the judgment in the court.
My lords.
So, মই ইয়াতে dictate কৰি দিম। Mr. B. Assisted by so had Mr. D. Gogoi representing all the respondents.
My lords. No, my lord, please. DC has seen every. My lord, note, respondent 3 is represented by my senior man. 4.
Or
3.
Evans in that petitioner is running a restaurant in name and side of Sir's Angel Restaurant at Pandu, Sadilapur, had applied for an on shop license in her restaurant by converting the name to Messrs. Angel Bar and Restaurant. Full stop. On consideration of the application filed by the petition, the application. Due verification had been carried out by the agents in the excise department, and thereafter the government had accorded sanction for the MFL on-shop license by the order dated 25/2/25. The petitioner thereafter deposited the 10 lakhs to license fee and security, etc. Acting on the sanction issued for grant of license, the petition also carried out renovation of her business premises. Stop. However, the respondents did not issue the IMFL on-shop license, and petitioner had to approach this court by preferring WPC number 4. Stop. The said writ petitioner was withdrawn by the writ petitioner since the respondents had taken a stand that the respondent number had requested the respondent number 3 to halt issuance of IMFL on license to the petitioner, despite the sanction having been already granted. Respondent number 2 filed communication dated 26/5/05. Right? This writ petition has now been instituted, sealing the letter dated 26/5/2025 and for directions to the respondents to IMFL on-shop license in consonance with the sanction already granted by the communication dated 25. Mr. B.D. Das Learned, Senior Counsel appearing for the petitioner, has submitted that the documents annexed to the writ petition show that the respondents had already carried out all the requisite inquiries regarding the application of the petitioner for grant of an on-shop license, and in furtherance of the sanction being accorded, the petitioner has also taken all steps necessary on her part to ensure that the issuance of the license is not delayed.
The total 10 lakhs.
Referring to the communication dated 26/5/2025, the Senior Counsel has submitted that the said letter was issued referring to a letter received from the Honorable Minister of Excise, which in turn referred to a widespread resentment among the public, students and faculties of the Guwahati University against grant of license petitioner. Full stop. Senior Counsel has submitted that all inquiries having been conducted by the respondents in of the Assam Excise, mere resentment by certain groups of people, who who are not entitled to raise objections for issuance of such license would not be a ground for the respondent authorities to deny petitioner her right to carry on a business in accordance with law. Full stop. And senior counsel has submitted that the decision to keep the issuance of the license on hold has been taken without affording any opportunity to the petitioner. And in fact, when such objections are not entertainable under the provisions of the relevant rules, the same should not have been referred to the disadvantage of the petitioner. The council has referred to the judgments delivered by this court in the case of Kaberi Das versus Assam and others. The cases of Deputy Commissioner of Excise versus MS Two Bandits Restaurant, decided by the High Court and reported in 2022 Supreme within bracket Delhi 872, judgment of this court passed on 22/6/2020 in the case of Jayanta Prasad Banik versus State of Assam within bracket WPC number 1751 of 2009, and also judgment and order dated judgment and order dated 14/1/2022 passed by this court in the case of Homeland Another versus State of Assam and others within bracket W 6339 of 201, to buttress that. Public opinion or sentiment is not a factor relevant or germane under the act or locate or when. Per contra, Mr. D. Counsel appearing for the Excise Department has submitted that was due to the widespread public resentment, particularly from students and faculty of Guwahati University, against the grant of the aforesaid license, that the department had to keep issuance of the license on hold. Stop. He has referred to memorandum submitted the Honorable Chief Minister of Assam by the All Assam Students Union, which representation had expressed that the liquor shop would act as a catalyst in destroying the academic environment of the university. Full stop. He therefore he submits that therefore there is no illegality. Excise Department refusing to issue license to the petitioner till such time as the differences are sorted out. Full stop. This court has considered the materials available on record and the submissions made by the learned counsels appearing for the contesting parties. Next para. Rule 289 of the Assam Excise Rules 2016 is relevant for the purpose of tracing the detailed procedure laid out when consideration is made by the respondent authorities as to the feasibility or otherwise of allowing an on-shop liquor license to an applicant. Full stop. The said rule is quoted for a ready reference. From a perusal of the rules, it appears that the liquor shops should not be located at sites to which neighbors object. Comma, that no IMFL or beer retail off license or on license shall be established in a municipal corporation area within a distance of 50 meters from any place of public worship or educational institution or hospital. Stop. The educational institutions referred to in the said rule mean primary school, middle school, and high school, or any college affiliated to any university, but would not include private coaching or tutorial institute. This court has referred to the term educational institutions without referring to other definitions, and as in the present case, the objections appear to have come from a students' union, and the objections raised relate to the disturbance that may be caused in the academic environment of the Guwahati.
Your Lordship, may kindly see 295(3). Who can give objections? 295(3). Roman 1, 2, 3. Person who can file objections.
Which one?
Rule 295. Roman
95.
295(3), my lord. For the purpose of Rule 289/95, objections from the owners or occupiers and residents never located within 75 meters and is involved shall be considered.
The learned senior counsel appearing for the petitioners has drawn our attention to provisions of Rule 295 in bracket Roman 3, which is to the effect that for the purposes of Rule 289, objections from owners or occupiers and residents of the neighborhood located a radius of 75 meters of the premises involved shall be considered. Full stop. In the present case, it is noticed that inquiry had already been conducted, and it is only thereafter that the government sanction had been granted for issuance of the IMFL license. In the case of Amlan Jyoti Mohanto within brackets Supra, this court had held that the objections raised by residents who were outside the 75 meters radius of the proposed IMFL on top would not have much bearing, would not have any bearing on the, would not have any bearing in as much as the relevant provisions of law do not require their objections to be taken account. This court is therefore of the opinion that since no procedural lapse part of the petition has been pointed out by the respondent authorities, making the application or even or and there were no objections till the time when the sanction was granted for issuance, comma, mere objections by persons who do not fall within the ambit of the rules governing the issuance of license, comma, the respondents cannot withhold issuance of the license only on the basis of such objections. Stop. Writ petition is therefore allowed, comma, directing the respondent authorities to take immediate steps or to take appropriate steps for granting the license to the petitioner, granting the IMFL license petitioner in accordance with the sanction already granted by the government to its communication dated
25/25.
25/2025, comma, subject to the petition still fulfilling all the required norms as was required to be fulfilled by him at the time of sanction of the sanction, full stop. Petition accordingly disposed of, no.
Within a stipulated time. Within a time.
The respondent will take all necessary as expeditiously as possible, probably within a period of 3 weeks. Date of this order.
Clear. In paragraph 13, I have mentioned there is a off shop also within 500 kilometers. I've
Within
just mentioned
500 meters.
500 meters. There is a off shop going on. I'm just mentioning,
That we
not
will put if
necessary.
They take an objection because this excise rule says
No,
that
it's
you
a-
cannot have a distributor and a retail shop on the same premises.
That is different.
That already that aspect, I think they have. That is anything else you require?
Nothing.
Problem.
Okay.
আমার কেটা মেটার বাকি আছে? Can we take it up after?
Yes, yes.
We just refer to 17, 18 and 19 if.
No problem. I'll be
Then is
happy.
required. Yes. 17 to Matoksun?
So I may come after half an hour.
I think there are only 3 matters.
I will be here.
Yes.
Matter record is called for.
Because the matter relates to
Petitioner is the L2 bidder, but
Huh?
petitioner is the L2 bidder, but the L2
Yes,
Yes,
yes, Mr. Tarika, what do we do?
yes, my lord, that record was required to produce today.
Records. Mr. Gupta. Mr. Nayak, please call him. Sorry, next. Yes, sir, what was this matter?
My lord, in this case, my lord, the two writ petition has been filed.
Licenses were suspended. Some
My lord,
licenses were
yes,
suspended.
license suspended.
Yes.
And my lord, then corporate inquiry was, my lord, also conducted, my lord. Now, in this two writ petition, in the first writ petition, 6052 of 2023, my lord, that regarding, that we assailed the property of the search and seizure procedure, my lord. In my humble submission, my lord, that was not done in accordance with the provision of law. What should have been done, they have not done, my lord. So this first writ petition 6052 is relating to that, my lord, property of the search and seizure procedure. And second writ petition, my lord, after the search and seizure, they issued a suspension order. Then, my lord, there some conduct some inquiry. they have taken the statement of some of the complainant, my lord. We do not know. But behind our back, no document, nothing has been furnished to us, my lord, to make our, my lord, the proper representation in the matter, my lord.
So if this writ petition is disposed of,
Lordship.
setting aside
6053.
whatever, setting aside the actions,
Yes, my lord.
allowing them to take course as is required in law by issuing you a notice and taking a final decision, will that suffice?
My lord, what I respectfully submit in this case, my lord, let them, whatever the document, they submit an inquiry report, my lord, in the next case, 319. The lordship will find the head inquiry officer has already recommended that this license should be cancelled. The lordship is aware.
Inquiry officer's recommendation is only a recommendation.
Yes, my lord.
That goes.
Then, my lord, in the inquiry report, they based on many documents, my lord, complainant.
You were not a part of the inquiry.
My lord, I was part of the inquiry, but I paid for all the documents so that I make a fair submission, my lord. Because it's late, because the acts emphasize, my lord, even the principle of naturalness emphasize, my lord, that all the document which has been used against me should be furnished to me, my lord. I have made a submission.
Mr. Nayak, are you appearing in this matter?
Yes, Lordship.
18 and 19.
18 and 19. In fact, Lordship, today the matter was fixed for delivery of judgment, in fact. This matter was extensively heard by my Lord Justice General. But suddenly, Lordship, he had to go to Pahing Organs.
Okay, then we do not take it up again.
I am leaving it to your Lordship.
No.
Otherwise, I have no objection. Lordship.
Because
Oh, no. Due to paucity of time, matter could not be taken up today. Matter shall not be treated as
That is
part
correct,
or
Lordship.
time.
We extensively heard this matter, Lordship.
Actually, my lord, we also submitted a written argument also as the as part of the court, my lord. Court, we have written argument.
Probably in the next week.
Next week, Lordship, it will be. Lordship, I fix in the second week, Lordship, probably he will be here, Lordship, by that time.
You keep it on the second week of December. The earlier court which heard it is here. If it is listed before, it has heard it. Otherwise, we'll take it up. If it comes before us, we'll come up.
From my friend, Lord. I have.
My lord, my humble submission.
Otherwise, you
is, no, my lord, at this stage, my lord, I leave it to my lord, my lord. But my humble submission, at this stage, my lord, since it is a matter of facts, as far as my lord may not be able to tell all these issues, my lord. But the thing is that since I have challenged the very propriety of the procedure, that my documents are not had been submitted, and we have there no fair opportunity, because the fair opportunity has to be given, my lord.
Not this
So-
fair
No, no,
opportunity
my lord,
argument.
no, my.
It has been raised now, Lordship. Earlier,
No,
his
no, it was
argument
raised-
was that it was
it was
section
raised.
100 of CRPC was not properly followed.
It was raised in the
As
writ
regarding
petition, it was
independent-
raised, not that it was not
No,
raised.
if giving up the second part, and he says that there is an inquiry report. In that inquiry, I had asked for some documents. I was not given the documents. I present myself properly. If court finds that the documents were not provided to him, would have helped him in his defense, then the inquiry report has to go.
Otherwise, Lordship, in this case, the final inquiry report is already there, Lordship, but it is not yet issued, Lordship, because of the interim order that is existing in this.
So be it. If he grounded, he was given enough opportunities in inquiry. Inquiry report has to go, and the only option he has is of being provided with whatever documents he requires. Hearing has to be redone.
That is a stand, Lordship, he is taking now.
Are you
In the
disputing
writ
it?
petition, that stand is
Why not?
there.
I can show right now, my lord.
Lordship,
That
at
is,
this stage, Lordship,
yes.
inquiry was not even completed.
No.
Now it is inquiry is
No.
over, Lordship. And
How we
at
come to
stage,
know, my
inquiry
lord?
was continuing.
This report, inquiry report,
Yes,
was,
inquiry report,
no, my
that
lord,
is the
that-
official
let me say,
stand,
that
Lordship.
inquiry report was submitted along with the affidavit in opposition.
Either we take it up for hearing today after some time,
Lordship,
because we are in the midst of a part
Or-
matter, or we keep it on some other day, your convenience. I am here, your convenience.
No, Lordship, Lordship.
Huh?
Lordship will decide. Another day then, Lordship.
Then we keep it for some time. If again there is a paucity of time, we'll not be able to. Otherwise, we hear the 16.
Because here, my lord, two things involved. First is the property of
Here
the
it when we
search and
take up the
seizure,
matter, sir.
and secondly is the, my lord,
We'll
loss.
In the second week of December, Lordship.
second week of December.
Loss. Only a date may be fixed, no lordship, otherwise,
List this matter again on the 9th of December 2022.
loss.
Ghosh, yes for the petition.
State property.
Yes for the respondent. The other matter, this.
It's
I think-
17 lots.
17
Lots of in this matter, lots of today, I'm only making the submission to the extent that it was a tender of 2023 lots. And the estimate was even prior to that. Like even if this matter is decided, either lordship will decide either my favor or his favor not. Even if it is decided in his favor lordship, whether he will be ready to execute the contract at a rate lordship which was prior to 2023, that is a question lordship. So let him first take that instruction lordship. If he is ready to execute the work lordship today at a rate prior to
If his
2023.
rejection was wrong, can it not be that it will be done afresh?
And another point, Lordship may point out.
But you have already, I think, you have not proceeded with the work.
No, work has not been
No,
allotted to anybody lordship.
Only one thing, my lord, from the affidavit filed by the state, my lord, it appears that due to his poor performance in the earlier work, my lord,
We are not convinced on that, sir.
no, my lord, that is the policy decision, my lord. Lordship will decide that, yes, my lord, the
Just
state,
a minute, sir. There's something on policy decision.
my lord, the state has stated that due to the poor performance,
That
yes,
is a ground in the
ground.
tender document.
Only ground they have
Be-
taken, my lord.
On that
Only
ground,
ground they have
authority may
Make
decide.
submissions which.
It will definitely depend upon lordship satisfaction.
Yes,
Huh?
my lord.
That reason is available in the tender document, but it will be depend upon lordship satisfaction.
Yes, my lord.
Not only that, we are more than being concerned as to why he was rejected.
My lord.
We're more concerned on when your page 13 shows that L3 did not satisfy anything. Why did it do that?
The record will reveal, my lord. I have the instruction, I have.
Lordship.
Yes.
Record I have, but that is the only reason, only submission my today lordship. Let him get the instruction lordship.
Because otherwise, suppose we close the writ petition, then he continues with the order. Or do you
He
you
has
draw
not
back?
yet been allotted the work.
So what is your proposal? You are allotting him the work, or you are going to withdraw it?
No,
If you are
lordship,
allotting to him the work at the same rate, why would he not do it at the same?
I don't know, lordship, what will be the, stand of the respondent lordship. Same is the situation
Same
for the both
situation,
sides.
it will be same situation.
You said that you are not interested in the. Why should we point out a mistake? If the government, if the respondents say that we are not proceeding with this work, we'll go for a fresh tender, that very moment I can close it. I can close it down immediately.
That is why lordship, I'm just saying, submitting lordship. Get him
Did not.
that instruction.
You will not be carrying, you will not be able to carry out the 2023 rates. What was that, what was the,
Tender
you are
was of
supposed to build a road,
2023.
you will not be able to build a road on those rates. Also have your instructions if you require to prep this particular process.
No, if lordship directs lordship decides is against me lordship, then I have to go with the work lordship. And at that, in that situation, lordship, subsequently, they will have to say that, no, we are not ready for. That's why I'm saying, you take that instruction before.
But as per my client, he is ready to do the work, my lord.
At that rate.
My lord, now, if he can do, then why not he?
No, it will
And
be,
well,
it will be after the decision of this honorable court.
It is a decision to be taken by both sides, lords.
Can kindly show us from records as to why L3 was given. If it is possible.
Lord.
Because he did not give some tax returns.
Sometimes I have to, my lord, yes, ma'am. It
You have not
it
given
will be from the
the
record, my lord.
financial turnover. Not give it, not give the balance sheet. Bank
Sometimes
credit
he has
facility.
completed for 5 years.
Where?
Lord, yes, my lord. Your lordship will see that column number 9. Income tax last 5 years. Comment is
23
yes.
and 24 not.
No, my lord. Lordship will see that 24, 23, 24 assessment year, it will be submitted in the first week of, in the July 24, my lord. The tender of 23. That aspect of your lordship will see, my lord. Assessment for the year,
Why was respondent, why was the first person,
no, no, my lord.
why was the first person rejected? He did not fulfill the conditions.
No, it's
Did not.
that L1B there.
Huh?
Oh, that, he has not come up, but his lordship will see the last.
Why
last
was he
column.
rejected? Why
Last
was he?
column, my lord.
Why was it rejected?
He has not rejected, madam. The last column your lordship will see. Fulfill all the conditions. Yes, 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 yes.
Who?
Their status. L1 bidder was,
Yes, 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 yes.
L1 bidder has come, not come up for other reason, madam.
L1 and the was not offered the work.
No, my lord.
Chart before us, L1 has some more cases than you. Yet he was not offered.
My instruction, he has not come up, my lord. Mirul Hazarika. Not that his tender was rejected. He has not come up.
You are not understanding query of the court.
My lord.
When L1 has been rejected because of certain shortcomings.
That
LP
observation will
has
come.
more shortcomings.
That observation will come from the record. Yes.
Search out in peace.
So my instruction that L1 has not come up. Therefore, consideration of L2 and the L3 was there.
Sir, Lordship, this is the record. In fact, I have flagged 2 page, Lordship. Lordship, may kindly see, or Lordship will give me some opportunity to go through this, Lordship.
Opportunity.
In my understanding, Lordship, that is the rate is important, Lordship.
Rate.
Yes, Lordship. If it is a prior to 2023 rate, Lordship, in the year 26, whether they will be able to execute that work or. Let him take that instruction, Lordship, finally. Subsequently, he will not be able to.
And your quoted rate was not correct.
Then the whole process may be taken.
Will interfere with his selection at best. Why should we scrap the whole process? Road.
Lord, as because the petitioner fulfill all the conditions, my lord, and he is ready to do the work. The whole process is not fair, man.
In that situation, next week, Lordship will take up this matter for final hearing.
In a petition advocate general for the respondent number.
One
For the official respondents. Hazarika,
That's number 7, my lord.
when? Number 6, no one appears.
I have been, but.
As respondent number.
Education আছে.
7 years served by Dasti.
7 I am appearing.
6.
Steps, I have taken steps, madam.
Dasti steps.
That's the step.
And he has not participated.
Not participated.
It is submitted that despite Dasti steps have been taken on.
Fifteen 2023.
Oh, you have not filed your.
Malad, I have filed.
Dusty
You have filed your Dasti actually.
file question মোক এটা কথা
Malad, I have filed.
When?
Malad 8/1/20. Oh, this is next set. 15/12/2023. I have submitted. This is the acknowledgement.
Affidavit has also been filed by the petitioner. Service of notice on Huh? How do you take the steps? That receipt is not supposed to be annexed.
Yes, ma'am. That notice needs to be annexed.
Mr. Mazumdar, we give him this copy, he gives a signature.
And he quoted. The next basis of. Like to get it.
We cannot take it up for hearing unless we.
And that, this is the.
Receipt of the respondent of the notice started by the learned.
L1 to store receipt corona, he did not turn up. L1. No, no, L2,
Document.
L1. No, L1, L2.
Record. Referring to a document which shows natures of the respondent. Video. The petitioner shall file an affidavit.
L1, L2,
Fixing
L1 middle hazard.
service of notice on the respondent numbers.
Recording it. Physically. It was statement.
Again. Thus. 30 weeks. A date to be fixed by the registry. When along with the affidavit required to be filed by the petitioner. Unless you file that, we cannot deem notice upon him. Cannot take it up for hearing. His absence. Or he'll come back to say, I had something to say. You made him a party. You filed the affidavit with that piece of paper saying that he has been served. Then we'll fix it. Good, no?
Dental.
Right? Which steps? Okay.
Yes, sir.
Well, I have gone through the award.
Hmm.
And it seems to me that the award is very nicely written. The learned presiding officer discussed the case of the workman. He has also discussed the case of the employer. And he has formulated the point to be involved here. And accordingly, he has applied this point of law and passed an award. And I have also gone through the evidence on record. There is no perversity whatsoever, so far the evidence is concerned. So far the work, at least so far the workman evidence is concerned. Now, my lord, straightway let us come to page 162. What is the contention of the union?
$62.
So
para 3 of the award. Now, what happened, Lord, so far this case is concerned? Yesterday, of course, I have narrated this thing, Lord. The union submitted a charter of demand for fixation of their wages.
Where do we find that?
I will come to it. Let us come to paragraph, let us start it from paragraph 3. On page 162.
There are two paragraph threes. At page 160 and the other at page 1. (159) case of the union. 59 is the case of the union.
159. Let us keep it open, Lord. Evidence. Let us come to the page
162.
Page 162. The written evidence of MWT to Hitesh Chandra Joshi, advisor, finance advisor of the Assam Carbon Products Limited, Hirkushi, Guwahati, is the replica of the written evidence of MW1, Vasanto Kumar Shoikia. Shoikia are two speakers of the same facts. They relied and exhibited some documents. It has come to in his cross-examination that as many as 10 workers were dismissed. 10 workers were dismissed from the service were involved with the incident that occurred on 16/7/2009. On 16/7/2009, an incident occurred, Lord, where the management wanted to bring out their finished product to give it to the outsourcer. Then the workers obstructed it. And thereby, a hassle took place. And thereafter, they conducted a disciplinary inquiry and 16 persons were, 10 persons of, 10 number of persons were dismissed. He also admitted before this court that he had not filed any financial record statement, etc. before this court to show that the company was running loss. Evidence of C. Dhiren Bholare, that is the evidence of the union. An operator by profession has stated in his evidence that his union, Assam Carbon Workers Union and Employees Union placed a demand known as a Charter of Demand, COD, before the management, and the demands were pertaining to the wage and facilities to the members employed in the establishment. I have gone through the evidence, I will rely in the later case. Facilities to its members employed in the establishment. Both the union and the management in a joint session arrived at a memorandum of settlement dated 10/5/2005. This settlement, after the expiry of this settlement, this first charter of demand was submitted.
After the memorandum of settlement, another charter of demand is being submitted.
For fixation of wages. That will be evidence from the evidence of record. But the management did not implement the terms and condition of the settlement. The management unlawfully declared lockout of the establishment with effect from 9/10/2007 to 2025/2008. That is the first lockout. Yesterday I third level. Thereafter, the management succeeded to form another trade union. Succeeded to form another trade union in the establishment with the name and style of Assam Carbon Staff and Workers Union. And the management executed a fresh memorandum of settlement with that ACSUW in state of Assam Carbon Workers Employees Union. That is the newly formed union, they arrived at a settlement. Now, your lordship, come to paragraph 9. Yes, paragraph 9. Mr. Kolita, that is, no, this is a case where the lawyers were not appeared. In this case, lawyers had not appeared. Management case was represented by their advisors, by their representative, and workman's case was also represented by their union. This is in view of the provision contained in section 36 of the Industrial Dispute Act. By which,
Santo Kumar Soikia was hearing for the management. Hiren Bhurali was
no, Mr. Kalita, Vasanto Kumar Kalita, paragraph 9, representative of the union.
Kulita.
So if your lordship goes to
Soikia.
Mr. Sekia and Mr. Kalita.
There are 9.
Both of them are not lawyers, not. They are representing union as well as the workmen. So that is in view of the provision contained under section 36 of the Industrial Dispute Act. I read it, you see. Idea called section 36, representation of the parties. A workman who is a party to a dispute shall be entitled to be represented in any proceeding under this act by any member of the executive or other office bearers of a registered trade union of which he is a member. Any member of the executive, other office bearers of a federation of trade unions to which the trade union referred to in clause A is affiliated. C, where the worker is not a member of any trade union by any member of the executive or other office bearers of any trade union connected with or by any other workman employed in the industry in which the worker is employed and authorized in such a manner as may be prescribed. Now, subsection 2. Similarly, an employer who is a party.
If both the parties had agreed, they could have a legal practitioner, otherwise they could have anybody.
Yes.
Yes.
Here both the parties was not agreed. Now, paragraph 9, the workman case. Mr. Kalita Larned, representative for the union, submits that the union representing the workers had a justified ground for taking different educational program as because the management was not interested in solving out the problem suffered by the workers while performing their duties and also to the waste structure that is arising out of the charter of demand. Mr. Kolita submits that the lockout cannot be an easy way to get rid of the agitating workers. There are some provision in the Industrial Employment Standing Order Section 1946, the Industrial Dispute Act 1947, the Payment of Wages of 96, maintaining the discipline and the peace in the establishment. Mr. Kolita states that when the actions taken against one of the agitating workers, there is no justification of imposing lockout in the establishment. Next, my lord, paragraph 11, workers' case was. Kolita submits before this court that the workers had a charter of demand, COD, regarding the wage and facilities to the workers. And there is a grievance from the side of the workmen that in spite of taking several educational programs, the management did not consider their demands. It is also seen that the notices issued by the union to the management that the union always referred a letter dated 5/10/2009. So this is a 5/10 sent to the management. The management all along proceeding, that is 5/10/2009 is a Your Lordship may kindly record it as Exhibit G. 5 sent to the management. The management all along proceeding did not mention about this letter dated 5/10/2009. The union exhibited the said letter Exhibit G. The content of this letter is that on 24/9/2009, the union had sent a letter to the management stating that on 21/9/2009, as per the invitation from the management, the representative of the union went to the chamber of GP Chawla, General Manager Operation, for a bilateral discussion. But GP Chawla misbehaved the union members, and an allegation was brought that GP Chawla imposed unacceptable, absurd preconditions for settlement. Thus, the union expected that the intervention of the managing director of Messrs. Assam Carbon Products Limited, Kolkata, in that letter dated 5/10/2009, Exhibit G, the union informed the managing director of Messrs. Assam Carbon Products Limited, Kolkata, that the local management had been harassing the workers and trying to provoke the general workers to create abnormal situation in the factory for the reasons best known to them. More surprisingly, the management sent some unsigned letters by registered post to the individual workers with this sentimental words and highly provocative words, which created unprecedented repercussion. The bonus for the year, that is very much important. The bonus for the year 2008-9 had also not been paid. The union wanted the suspension orders issued to the workers to be withdrawn. The union also wanted the suspension issued to the work to be withdrawn. 20% bonus as paid to the workers and officers of Hyderabad. And other units. There's a Calcutta units. There are two units. One is Hyderabad unit and the other is Calcutta, near Bajbaj. In that unit, 20% bonus was paid. But here the no bonus was paid. 20% bonus as paid to the workers and officers of Hyderabad and other units, and also settle the conditions of COD, that is charter of demand, without any precondition. It was also informed to the management that to get their demands fulfilled, they would resort to tool-down strike, mass casual leave, comorbidity, etc. In Exhibit H, it has come as many as 19 workers were suspended on false and fabricated grounds, and also charge sheets were submitted against the some workers. Then Your Lordship come to paragraph 13. The union stated that the educational program to fulfill the charter of demand. The union has also brought that at the instance of the management, a separate union was formed with the name of Assam Carbon Staff Workers Union. Lord. This union is affiliated to INQC, Lord. At that point of time, ruling party was a Congress government, Lord, and they, instead of approaching the conciliatory officers, they approached Pithi Maji and Poddut Bardalek to their exhibit letters. That you please intervene in this matter. And they ultimately a union was formed, and that union was affiliated to the INTUC. And that with that union, a settlement was made.
Management.
by the management. And in this settlement, there is a clause whether the union, whether the workmen will get their due salary during the period of lockout, that will be determined by through an industrial adjudication. Pursuant to that clause, this adjudication was
That understanding was entered into when?
in that settlement itself.
Which settlement? The year?
Immediately, this settlement through which this
Lockout
lockout
was-
was lifted.
The second lockout was lifted.
Second lockout was lifted. This aspect was dealt with by the learned fee. The union stated the additional program to fulfill the charter of demands. The union has also brought that at the instance of the management, a separate union was formed with the name of Assam Carbon Staff and Workers Union. And the union, namely Assam Carbon Workers Union, the present union, and the employees union was not present in the meeting, and no memorandum was signed, settlement was signed by the Assam Carbon Workers and Employees Union. This fact was stressed during the evidence of the union before this court.
So there will be 2-3 unions, they have to go for a settlement with each of the unions. Could be.
There was actually our union is the original union. Subsequently, when this lockout was resorted to, a new union was formed.
And which was registered.
Which was registered.
Your union did not remain, did not get that
No,
registration.
sorry, Mr. Union. This union, with this union, the management made a settlement. And after that settlement, the lockout was lifted.
And it is because of that settlement that the matter went for adjudication.
Yes.
Not because of the settlement with your union, but because of the settlement with the other union. The other union is not a party in this.
That is different. But whether it will be, other union is not, now that union is not in existence. It is my instruction.
No, maybe or maybe not, but the
No,
reference
that is
was
not a
made-
problem. That is not a problem.
This litigation started because of that union. The agreement with the union which UNA say is not existing.
No, whether that union, that agreement, that settlement is also binding on us.
That I think the High Court has said that it is.
Huh?
High Court has said it is.
Yes,
Close
yes,
to
that
the-
settlement is binding on us also.
All of you.
Actually, we had challenged at one point of time, we had challenged that settlement. Then High Court says, no, this is a fair settlement, this is binding on all. So this is not very relevant point now yet. It is also nobody's case below. And no memorandum of settlement was signed by the Assam Carbon Workers Union, Employees Union. These facts stressed during the evidence by the union before this court. Against these facts, the management has not advanced any counter. The union's demand was regarding the wage and condition of service of the workers. The management plea is that even Millard, assuming that there was no settlement, then also Millard, we have the right to espouse a dispute whether we are entitled to have the wages for the during the lockout period or not. Because this will be an industrial dispute. Even assuming that is. So this is not very relevant point. The management plea is that even before and after the execution of memorandum of execution workers carried out in the different educational program in support of their claim, it is seen that the management did not try to, that is very much important. It is seen that management did not try to go to the root as to why the workers were continuing their educational program. Even after execution of MOS, the management plea is that the representative of the workers attended the meeting and they signed the MOS. Thereafter, the workers had to follow the conditions laid down in the MOS. It is the plea of the management that the workers had also resorted to program to go slow. Management witness number 2, who is none but the advisor, finance and accounts of Messrs. Assam Carbon Products Limited, Birkuchi, Guwahati, 26, stated in his evidence that no statement or report has been filed before the court to show that the company was suffering loss. Exhibit 5 and Exhibit 6 are two letters issued to the two cabinet ministers. That is where the starts problem. These two cabinet ministers. And they intervened in this matter. And the union was paid. Exhibit 5 and Exhibit 6 are two letters issued to cabinet ministers of the government of Assam. Exhibit 5 is addressed to the Minister of Labour and Employment, Mr. Pithi Majid, Government of Assam Dispute. And Exhibit 6 is a letter issued to the Minister of Industries and Commerce and Power of the Government of Assam, Pradut Bardoloi. The two letters are same words by word. Though the said letter, through the said letters, it was informed to the government of Assam that the management of the company was in a serious doubt whether the plant in Guwahati would be able to continue in operation due to unreasonable hostility of the unproductive as well as paid workmen. Therefore, the management sought help from the police and district administration. It has not come, it is very much important. The crux of the problem lies here, in my opinion. It has not come that management had taken initiative to resolve the educational program at early. The management, for the greater interest of the company and workers, ought to have initiated a joint sitting by involving labor commissioner. Instead of involving labor commissioner or the conciliation officer or taking any state for making a officer, they straightway approach to the ministers.
The tribunal, according to you, is trying to say that the failure of the management to strikes, go slow, and all the others, that led to a very bad situation. The lockdown had to be. Therefore, the lockdown was not just.
No, according to the management,
According
that
to
we
the
are
tri-
resorting so many educational program. And situation, according to them, situation becomes so serious that they are not in a position to run their industry. They sought intervention of the ministers. And ultimately, they have resorted lockout. So in this point, Lord, the learned presiding officer was of the view that there is a conciliatory machinery. There is a labor commissioners and other officers, and adjudication machineries, and arbitration machineries.
If the payment of wages was being violated, or if the payment of bonus was being violated, resorting to strikes, and this statement of the according in the tribunal's order, that roads were blocked on 4/12/2022, threatening the executives, restraining willing workmen from work.
And for that reason, 10 workmen were dismissed.
On 16/12/2010, this happened.
2009.
7/12, the lockout came.
No, it is 2009.
Page 159. I'm sorry to disturb you.
No.
But page 159.
No, that was the.
This is the workmen's written statement. The workmen union first filed written statement. Case of the union is that management had declared lockout with effect from 7/12/2010 on the ground of financial loss, so and so, disregard to direction. It was also stated in the lookout notice that workmen had blocked the road
on 4/12. It is a management contention.
On 4/12/2010.
Leading the factory paralyzed the operation of the plant by shouting slogans.
Number one. They also threatened
the executive to restrain the willing workmen to enter into the factory as on 6/12/2010.
The workmen
lockout was resorted on 7/12/2010.
Workmen on 6/12/2010, workmen remained absent.
the management was not in a position to control the situation, therefore they compelled to declare lockout.
Now, this is not rebutted by the workmen anywhere.
No problem.
So, if that was the situation when the lockout was declared, because in very quick succession, the road is blocked, the executives are threatened, people wanting to work are not being allowed to work, and thereafter, everybody remains absent on absent on 6 to
Yeah, what?
So the initiation that a
Yeah.
lockout is not necessary, otherwise things will go out of hand.
No, what was the real reason is that this had happened because of the
The lockout is not because of the strike or the demand as such. Lockout is because of these incidents.
No. Lockout was because of the demand. Yes, this will be clarified by paragraph 13. This is not an isolated incident.
Huh?
This is not an isolated incident.
It was building
What-
up, but the incident which
Well,
immediately
we have submitted a charter of demand. In that charter of demand, there are probably three demands. One is the fixation of wages. Second is the revocation of the dismissal orders. And third was the payment of bonus. We approved before the manager again and again to have some discussion with that. Management had not paid any attention to that.
payment of bonus is a mandatory requirement under law. Why discuss? Why discuss? Why a strike?
Yes, because it is discussion is required. Because minimum bonus is 8.33 and maximum bonus is 20%.
So you are demanding 20%.
We are demanding 20% because of the fact other two establishments at Hyderabad and Kolkata, they have paid 20% bonus.
But you were paid 8.33.
Actually, we were not paid at that point of time. No fixation of wages. So here, what happens-
Since the justifiability or justification of the strike is not an issue, we have not agitated it. We will not look into that.
Justification strike is not the issue, justification of lockout is the issue.
Lockout. The lockout, if it has happened because of these.
Because why it has happened, that has been discussed.
Incidents
There's
from
a
412
management without
From
taking
412 to 712, whatever happened. 412 and 712, whatever happened in between, management went for a lockout.
one point
Can
lockout.
it be traced to the original charter of demands?
Yeah.
Can it be traced to the charter of demands?
Yes. That will be relevant. We go through this award. Because we want to settle this our charter of demand.
So long as the workers were on a strike, going slow, there were some other steps that the management were taking, trying to get in the minister, trying to do this, trying to do that, have a sitting, person misbehaves, whatever happened. They were trying to do something. Moment it turned violent.
No,
It is then the
so-called violence, no, they have blocked the road.
And they assaulted Anupam Goswami.
No, that is
They assaulted
no.
Vikramjit. No, that is prior to.
That is the
I'm
prior
sorry, that is
occasion. For that reason,
Then they threatened.
but at one point of time, what happened?
They threatened
management
executive
wanted-
and restrained willing workmen.
Management wanted
getting
to.
violent. When they're threatening executives and restraining workmen.
No. So far, this threatening is concerned, that is prior to this.
412 and 612.
Yeah, one Mr. Goswami.
That part gone. That I.
And for that reason, 10 persons were dismissed.
No, even if we leave that aside, 412 road blockage,
Road blockers.
threatened executives, restrained willing workmen. 612, everybody remains absent. These three incidents, were they not violent enough to go for a lockout?
Yes, well, why these three incidents occurred, had to occur. That part has been discussed by the learned presiding officer. That it is due to the fact that you have not taken any steps whatsoever to settle the dispute by taking recourse of the conciliatory measures. And the union also blamed that they had not taken any steps to settle this, their dispute by taking conciliatory reasons. Straightway they came for these educational programs.
The justification be drawn to that.
Now let us come to
Lockout was immediately because of this. Is 412 to 612 not having occurred, it would have dragged on. The strike would have dragged on. An unjustified strike would have dragged on. Sudden violence, protection,
Not violence,
lockout.
obstruction.
Threatening executives,
Party.
restraining people from work, going to work.
These are usual things in every local, every strike. You know, if we come across the bank strikes also
These
there.
are not incidents which happened before. These incidents did not happen before, if they are usual enough. These allegations are only between
in
4
the
to 7.
earlier lockout also.
Ah.
This kind of incident occurred.
If it is unjustified now, it was unjustified then also, these acts. And therefore the tribunal said that it is unjustified.
Unjustified.
Now the lockout, which is an immediate outcome of the
Strike is
unjustified
unjustified.
act. At the initiation, it will remain justified. That lockout had to be there. Otherwise, there would be worse situations.
Yes.
We cannot expect the management to wait for a worse the FIRs being lodged, the running around being done. Seen from that angle, the initiation is not unjustified of the lockout.
No, so
The
why
factors
it
leading-
has occurred, had to occur, that aspect of this case was discussed.
It occurred because according to the workmen, their queries were not being appropriately answered by the management. Their requests were not being met by the management or not being sorted out by the management.
Now
That
the
was not the
presiding
reason for the lockout.
officer was of the view, instead of resorting lockout, you should have taken the help of the conciliatory methods as prescribed under the Act. Because according to the presiding officer, lockout is the last resort. Let me assume that the strike was unjustified.
Huh?
Let me assume that the strike is.
The strike was unjustified, and more unjustified was the immediate happenings of 4 to 7. From the 4th to 7th, whatever happened, that was more than unjustified.
Let me assume all this.
For which the premises had to be locked out.
Yes. Now, what is that your lordship agree with or not, that is defined thing. What is the reasoning even?
Before agreeing or disagreeing, we'd like to have a discussion. Therefore, we express our minds. It is not because we are trying to be
Because of
against you or
this,
with you.
The learned presiding officer was of the view that instead of taking the conciliatory measures, straightway you have resorted to lockout.
So
That is unjustified.
after the threat, after the road blockage, and after everybody remaining absent,
Let us
first step
read the,
should
let
have
us
been
read the paragraph 13.
the first step
Let
should
us
be
read the paragraph 13.
conciliation.
Let us read the paragraph 13, then it will be clarified.
Yes.
The union stated the educational programs to fulfill the charter of demands. The union has to broad that the instance management, a separate union was formed with the Assam Carbon Staff Workers Union. And the union, namely Assam Carbon Workers Employees Union, was not present in the meeting. And no memorandum of settlement was signed by the Assam Carbon Workers Union or Workers and Employees
You have
Union.
read this, sir.
This
while
fact
ago.
was stressed. No, let me start it. During the evidence of the union before this court. Against this fact, the management has not advanced any counter. The union's demand regarding the wage condition of service of the workers, management pleads that even before and after the execution of the memorandum of execution, the workers carried out defined educational program. This may be wrong on the part of the worker. Program in support of their claims. It is seen that the management did not try to, that is very, it is according to him, maybe that is his view, and I would like to support his view by referring certain judgments. management did not try to go to the root as to why the workers was continuing their educational program. Did not try to go root as to why the workers were continuing their educational program even after the execution of MOs. Management plea is that the representatives of the workers attended the meeting and they signed MOs. Therefore, the workers had to follow the conditions laid down in the MOs. It is the plea of the management that the workers had also resorted program of go slow. Go slow. Management witness number 2, he is none but the advisor of the Finance Accounts Carbon Products Limited, Virkuchi, Guwahati, stated in his evidence that no statement or report has been filed before the court to show that the company was suffering loss. Exhibit 5 and Exhibit 6 are two letters issued to the two cabinet ministers of the government of Assam. Exhibit 5 is addressed to the Minister of Labour Employment, Richi Oja, Government of Assam, Dispur. Exhibit 6 is the letter committee for be able to contract. Now, I have read this thing. Now, therefore, the management sought help from the police and district administration. It has not come to that the management had taken initiative to resolve educational program. Educational program started long back. At early, the management, for the greater interest of the company and the workers, ought to have initiated a joint sitting by involving the labor commissioner or the government to avoid the further educational programs taken by the workers. It is seen that instead of resolving the problems in a joint sitting with the union executives, the management had involved police, district administration, and the ministers of the respective departments of the government of Assam. That is his view. Now if paragraph 14, he has explained. Strike is a weapon in the hands of the workmen, while lockout is a weapon in the hands of the management. Section 24(3) of the Industrial Dispute Act 1947 provides that a lockout shall not be deemed to be illegal if the lockout is in consonance of an illegal strike. Here the strike is not illegal, Milord. It may be unjustified. May be unjustified. Lockout shall be deemed to be illegal if the lockout is in consequence of an illegal strike and vice versa. Generally, strike here is important. Generally, strike is resorted by the workers when they fail to bring the notice of the management to their grievances, and the lockout is imposed when the management finds it impossible to run the establishment due to acute problem of their internal or external. Therefore, at the time of the application of the evidence to justify lockout of the strike, the materials against or support the strike or lockout are taken together. These two factors should be considered alone. Industrial legislation provides for peaceful solution of the deadlock that comes between the employer and employee. They are conciliation, arbitration, refunds, etc. If the industrial legislation is not followed, then there must be a provision either in the standing order, or the service rule, or regarding solving any dispute between the employer and employee. If the strike or lockout is found contrary to the standing orders or service rule, then the same will be illegal. Thus, the burden does not get discharged simply by proving that the lockout to be justified. At the same time, it is also incumbent on the part of the management to prove that the lockout imposed by the management was a last refuse. Was the last refuse to protect the man, machines, and establishment. Now, Milord, the learned presiding officer discussed some cases here, Milord. So, Milord, before referring reading those cases, Milord, I would like to place my submission on the basis of the certain judgment of the Supreme Court. Whether lockout is the last resort or not. That is, yesterday, Your Lordship asked me. I had to go through those judgment. It took some time to. आगे Supreme Court judgment होता. There is first case is constitutional bench judgment. Let us indicate them. Yesterday, probably I gave this 1990. Extra copy আছে? Yes.
Citation, please. Citation.
1994, this case was cited by you.
Syndicate.
You have cited, paragraph 25. You have cited. 1994, 5 SCC 572. This case was referred by my friend, learned friend also. He has referred paragraph 24 and 25. I will refer paragraph 27 and 30. One thing that I should admit, so far this case is concerned, it is a case arising out of the banking industry, which was a public utility service period. Be that as it may, the judgment of the Supreme Court was discussed or relied upon on other judgments also. Paragraph 27. It has to be remembered. Let me read the paragraph 27. It has to be remembered in this connection that a strike may be illegal if it contravenes the provisions of section 22, 23, or 24 of the Act, or any other law for the terms of employment depending upon the facts of each case. Similarly, strike may be justified or unjustified depending upon the several factors, such as service condition of the workman, the nature of the demands of the workman, the cause which led to the strike, the urgency of the cause of the demands of the workman, the reason for not resorting to the dispute resolving machinery provided by the Act, or contract of the employment, or the service rules, regulation, etc. An inquiry into these issues is essentially an inquiry into the facts, which in some cases may require taking oral or documentary evidences. Hence, such an inquiry has to be conducted by the machinery, which is primarily invested with the jurisdiction and duty to investigate and resolve the dispute. The machinery has to come to its finding on the said issue, examining all pros and cons of the dispute, of any dispute between the employer and employee. So let us keep 28 paragraph. That is the submission of the council. Now 29. The strike as a weapon was evolved by the workers as a form of direct action during their long struggle with the employers. It is essentially a weapon of last resort. Right. Being an abnormal aspect of the employer-employee relationship and involve withdrawal of the labor, disrupting production and services, and running the enterprises. It is abused by the labor of their economic power to bring the employer to see and to meet their viewpoint over the dispute between them. In addition to the total cessation of work, it takes various forms such as working to rule, go slow, refusal to work, overtime when it is compulsory and a part of the contract of employment, irritation strike, or saying staying at work but deliberately doing everything wrong, running to strike, that is disobeying lawful orders, sit down, sit in, lay down, the different kinds of strike have done. Sir, the cessation or stoppage of work, whether by the employees or by the employer, is detrimental to the production and the economy, as well as being the society as a whole. It is for that reason the industrial legislation, while not denying the right of workmen to strike, has tried to regulate along with the right of the employer to lock out, has provided a machinery for peaceful investigation, settlement, arbitration, and adjudication. There is the contrary reversal. Adjudication for the dispute between them, where such industrial legislation is not applicable. The contract of employment and the service rule and regulations many times provide the suitable machinery. This is so what they want to say, the strike is a weapon in the hand of the worker, and the lockout is also a weapon in the hand of the employer. That is, now the next question that your lordship yesterday asked me, paragraph 30. The question whether strike or lockout, legal or illegal, does not present much difficulty for resolution, since all that is required to be examined. Answer, the question is whether there has been a breach of the relevant provision. However, whether action is justified or unjustified has to be examined by taking into consideration of various factors, some of which are indicated earlier. In almost all such cases, the prominent question that arises whether the dispute was of such a nature that its solution not broke, delay, and await regulation of the mechanism provided under the law of the contract or the service rule. Strike or lockout, this is important, the strike or lockout is not to be resorted to because the party concerned has a superior bargaining power or requires economic muscles.
Dasgupta, that is what we are trying to understand. The workers had certain demand. They went on a strike. If the case was that the management, in order to subdue strike or to not agree to the charter of demand, had resorted to a lockout, that since you are giving us demands, they are going for a lockout. That is another aspect. If the management had gone for a lockout,
Management cannot do this thing here. As you have charter of demand, you have submitted.
you are
That
going
is
on
an unfair labor practice.
you are going on a strike, and so we are declaring a lockout.
Yes,
That would have been a different status. That would have been a different.
That is the case here. Because we have resorted to a strike. According to the management, you have created such a situation, we don't have any other alternative but to resort lockout. That is their case. According to them, that you have restrained our willing workers to enter in the office premises, and you have threatened them. And so we don't have any other venue but to resort lockout, according to them.
Because you are stopping the people from coming in, you are threatening them, you are blocking the road.
No, but that is why we have resorted to this. Now, the direct presiding officer rightly or wrongly came to the conclusion that you are also responsible to have this situation, because this charter of demand was submitted since long back. The management workers wrote different letters. All these letters are there, not exist. But you had not responded for that. Instead of responding all these things, you take recourse to try to take help of the ministers and the police administration. So had it not been there, this situation would not have been arisen. Let me go to paragraph 30, Miller.
Yes, sir.
The strike or lockout is not to be resorted to because the party concerned has a superior bargaining power or requisite economic muscle, compel the other party to accept its demand. Such indiscriminate use of power is nothing but assertion of the rule of might is right. Might is right. Its consequences are lawlessness, anarchy, and chaos in the economic activities which are most vital and fundamental to the survival of the society. Such action, when the legal machinery, such action, when the legal machinery is available to resolve the dispute, may be hard to justify. This will be particularly when it is resorted to by a section of the society which can well await the resolution of the dispute by the machinery provided for the same. Well, the strike or lockout as a weapon has to be used sparingly for redressal of urgent and pressure grievances when no means are available to compel other party the dispute to see the justness of the demand. It is not to be utilized to work hardship of the society at a large, so as to strengthen the bargaining power. It is for this reason that industrial legislation such as the Act places the additional restriction on strike and lockout in public utility services. This is a case arising out of public utility service. This is banking service. So, these principles.
In this case, there was no immediate lockout, there was strike. That strike was held to be,
Yes,
intended to be unjustified. The issue of a lockout being unjustified,
but
therefore, at paragraph 28, 27, it has been held that the
paragraph
paragraph
30.
29 it has been held that strike is a weapon of last resort.
And
did not say that the lockout.
Yes, that has said in paragraph 30.
30 it says.
Yes. Because this judgment was referred in other cases.
30 it says.
Just now I have read it.
The strike or lockout as a weapon has to be used sparingly for redressal of urgent and pressing grievances.
For redressal of urgent and pressing grievances
when
no means are available. That is a lot result.
When no means are
available. That is a lot result. No means are available, or when available means have failed. Two things. You must take the recourse of the available means. And if the available means have failed, then and only then you can take the strike.
Okay.
That is my understanding, Glenn. Some of these judgment was also relied upon by reporter. অন্য judgment কি on I'm giving okay. I have only one copy. I will pass it to your Lordship. And that your Lordship may kindly note down. 99 1 LLJ, page 719. one LLJ 8719. ভারতীয় কর্মচারী মহাসংঘ versus DKW Limited and others. I will pass it to you.
भारतीय कर्मचारी
ভারতীয় কর্মচারী কামগার কর্মচারী
कामगार कर्मचारी
1 minute, let us see if we can. It's not.
This judgment was also referred in this case, paragraph 15.
LLJ 719.
719. The paragraph may not be carried because I have extracted it from legal. Let me pass it to you.
We have legal will. We can read, we'll just try to understand.
Legal?
Legal we have, we'll.
Fifteen. I'm just reading some one or two paragraph. The issue whether lockout is legal or illegal is one aspect. The issue whether it is justified or not is another aspect. The Apex Court has so noted in paragraph 9 of the judgment of Syndicate Bank, just now I have referred. Syndicate Bank, Umesh Nayak versus, the said paragraph needs to be reproduced for considering the arguments of the respondent. That issue is concluded, which read under. This paragraph 9 has been quoted below. Paragraph 9, of course, I have not read out loud. Let me read out this paragraph 9. They have put it out. The question whether a strike or lockout is legal or illegal does not present much difficulty for the regulation, since all the requirement required to be examined has to be answered. The question is whether there has been a breach of relevant provision. However, whether the action is justified or unjustified has to be examined by taking into consideration of various factors, some of which are indicated earlier. In almost all such cases, the predominant question that arises whether the dispute was of such a nature that its solution could not delay await regulation by the mechanism provided under the law or the contract of service rules. The strike or lockout is not to be resorted because the concerned party has a superior bargaining power. The superior bargaining power or requisite economic muscle to compel the other party to accept its demand. Such indiscriminate use of power is nothing but assertions of rule of right, might reside. Its consequences, lawless, anarchies, chaos, economic activities, which are most vital, fundamental to the survival of the society. Such action would be legal and machinery available to resolve the dispute, may hard to justify. This will be particularly so when it resorted by a section of the society which can await for regulation of the dispute of the machinery provided the same. The strike or lockout as a weapon has to be used sparingly for redressal or unrest, urgent pressing grievances, when no means are available, when no available means are failed to resolve it, it has to be resorted to compel the other party the dispute to see justness demand. It is not to be utilized to work hardship to the society at large, so as to strengthen the bargaining power. It is for that reason that the industrial legislation such as breeze and traditional resources. Paragraph 1. This is of course a case of lockout problem. This principle was applied, and this is not a public utility service. In the case of Maharashtra, they have a special act, unlawful prevention of unlawful and I have forgotten the name, full name, MRTU and PLP Act. Be that as it may, this aspect of this case was considered along with the number of judgments made.
A few paragraphs below that.
But this was relied upon.
The judgment itself is also relied upon to Priya Lakshmi Mills. Can we? In the same judgment, Priya Lakshmi Mills has been referred to. Where it says, it is at the same time permissible for the employer to prove that an illegal lockout was the result of such misdemeanor or misconduct of the workmen that left no option to the employer but to declare a lockout.
Defined issue. Now, so far, whether a strike or lockout is illegal or not, that is very easy to determine. Because if the employer or employee had violated certain provisions of the Industrial Dispute Act, then it will render the strike or legal lockout, as the case may be, as illegal. But the question is whether the strike or lockout is justified or not.
It was discussing justified. You use the words legal. This aspect is there. It is at the same time permissible for the employer to prove that an illegal lockout was the result of such misdemeanor and misconduct that left no option to the employer but to declare a lockout.
That may be. That may be other cases. Yeah. Let us come to paragraph 15 of this judgment. It has continued. What is paragraph 15 of this judgment?
Of this very judgment. Yes.
That is Mumbai Mazdoor Sabha and Bennett Kamal Limited case was referred. There is no such hard and fast rule. Depends on the facts and circumstances of each case. In the Mumbai Mazdoor Sabha and Bennett Kamal case, Company Limited, 1981 LLJ, page 112, single judge of this court observed as under. Here their last name. Respondent number 1 and 2 also claim that it is their inherent right to declare lockout. It is not bound, and it is not bound to adopt proceeding, declare such strike as illegal or compel few striking employees return to the work. This attitude of the employer reflects unawareness of the modern principles governing the relations of master and servant. Changing milieu cannot be overlooked, but the industry is run not only for the benefit of the employer or the employee, but for unseen and uncared for third force represented by the society at large. That requires that employer must take reasonable steps, enable the smooth running of the industry. And only after failure to achieve that goal, the last fatal step of lockout should be resolved. The employer in the present case has not taken any action whatsoever against the few striking employees before giving notice of lockout, and the circumstances, the allegations of cannot be said. How to inform? So, you also had this judgment, no? So I need not plus of him. Yes, judgment, देखिए. Mumbai Mazdoor Sabha, so I have referred it. 1981 LLJ.
The one which was referred to in this judgment. This judgment that was referred to.
This judgment, the Mumbai Mazdoor Sabha judgment. This judgment was referred in. This is a judgment of 99 1 LLJ 719. The Bharatiya Kamgar Karmachari Maha Sangh. Another case where that is earlier case, of course. This is 1980. 1 LLJ 112. I should have referred this case first. Instead of referring this case first, I referred the second case. Right? Anyway, 1981 LLJ page 112. Mumbai Mazdoor Sabha versus Bennett Coleman Company Limited and others. Para 10.
Sorry, you have to give it
1980.
1980.
1 LLJ. Page 112. So far legal is concerned, 1979 legal, Bombay 329.
Yes, sir.
What? Legal or LLJ?
Supreme today.
Supreme today. Paragraph number may not be tallied. Paragraph 10 and 11. Let me read. Paragraph 10. It is now well settled that a lockout can be described as antithesis of strike. Is it there? Then all right. It is now well settled that the lockout can be described as antithesis of a strike. Thus, a strike is a weapon available to the employees for enforcing their demands. Lockout is a weapon available to the employer to force the employee to see his point of view by coercive method. It is necessary that in the struggle between the capital and labor, either side could make indiscriminate and hasty use of weapon in their hands. It will not be right for the either parties to commence strike or to enforce lockout with impunity without exhausting reasonable avenues. Reasonable is that is conciliatory reference, etc., etc. Exhausting reasonable avenues for peaceful achievements of their objects. The idea of enactment is to maintain industrial peace, and it is well accepted that for such as far as possible, employees should not be thrown out of work, because that creates a social problem and topic productions and the interest of the society also suffers. The para 11 have some bearing. With this backdrop, if the problem in hand is viewed, clear that it raises a large issue whether the majority of employees throw out of the work for the default of a few, or more so, when the employer has taken no steps against these defaulting employees, though they primarily so permitted by law. But given some of the workers resorted to strike, but the majority of the workers were willing to work. So management, instead of taking those workers action, they have resorted to lockout.
From where do we find that in this particular case, the workers were willing? The workers, they were willing to work. From where do we find that?
This particular case.
In our case?
No, I am not trying that statement. So far, this case is concerned.
That is what, only if there is some similar, something similar, can I draw that line?
That is not. No, just as for your lordship's convenience.
That is what we are saying. On it says,
No, here is this case of what is that you have the avenue to
The
take action
employer-
against those.
the
But
employer-
instead of taking those avenues which were available to you, you have resorted lockout. That is unclear.
the whole issue, whether the lockout
That is not
was,
very relevant so far our case is concerned.
the lockout, when the lockout is declared to untwist the workers into submitting desires of the management,
What I have understood,
then it is,
what I have understood, the lockout and strike are weapon in the hand of the workers as well as the employer.
lockout under what circumstances? Lockout under what circumstance?
That has not been described in here.
It has been here itself. The employer did not think it prudent even to reply to the letter, but rushed to give a lockout notice. So there was some demand, some letter, and employer said, okay, we are going for a lockout. It's almost like we are going for a strike, we are going for a lockout. In that situation, other avenues are there, one should go and
Yes,
then
yes.
try and sort it out.
That is your lordship's burden.
What is striking us here in this case is, fourth, fifth, sixth, there were some incidents which required the lockout in the premises immediately. Because when the persons were agitating,
That is your
when they,
lordship's view.
that
That is your lordship's tentative of view.
tentative view.
But the presiding officer's view is that, then no.
If you had gone for settling the issues before, then 456 would not have
Your-
happened.
Your lordship may differ with his view.
456,
fine.
no, what I'm saying, trying to say is, tribunal says, if you had tried to solve the problem, 456 would not have happened. If
So
it did
your
not
lordship
happen,
says that
lockout
because
would not be
this is a
there.
Perverse spending. Then and only then your lordship coming.
If it is a possible finding, then I will not interfere.
Yeah. Your
Understood.
lordship
That
should
part is
differ.
understood.
I don't have any objection.
You may have a different opinion, but if-
Whether he has made a possible case or not, by assigning some reasons. One may disagree with that is different issues.
we may
But
not agree.
whether the reason is some value, reasonable value, it is up to him, he has decided. Now, my lord, yesterday, I referred one judgment of the Supreme Court, that is lockout may be initial stage, at the very initial stage. lockout may be legal,
Legal.
but the elapse of time become illegal.
Yes, where the
And
workers
63.
workers had given a letter that we are ready to work and the management did not take up
Uh-huh.
the this and therefore becomes unjustified throughout.
Yes.
Yes.
No, on reliance of that judgment, the
2005.
Huh?
Vietnam.
yes, sir.
They
That
did.
is SCC 2005 SCC online Andhra Pradesh 469.
এটা দিয়ে দে আছে এক্সট্রা কপি
And as extra copy of
এইটাই এইটাই
2005 SCC online AP 469. Equivalent judgment is, there are a number of equivalent judgment. 2006 1 LLJ page 16.
Hmm.
2006 1 LLJ page 16, 2005 3 Levi C.
Does it say?
The paragraph 10 and paragraph 16, I've forgotten what is this. Yesterday I wrote.
Oh, yes.
The tribunal held that it was the conduct of the workers which brought about the lockouts declared by the management, and therefore the lockout is justified in the beginning. The tribunal, however, held that though the lockout was legal in the initial stage when it was declared, it had become unjustified because of its long duration. The tribunal further held that the conduct of the part on the workers as well as the management was responsible for the sorry state of affairs, for the workers' unrest in the company, and in both had to be blamed for the sorry state of affairs. I have come across a large number of cases. I found that most of these cases, both the parties are to some extent responsible. To some extent responsible, that more or less. The management was responsible for the sorry state of affairs and for the workers' unrest in the company, and that both had to be blamed for the sorry state of. The tribunal considered it appropriate to apportion the blame at 50% each on the part of the workers as well as the management. Here in this case also that is done, that has been done, but not on this count, but on the other one. The portion, paragraph 60.
See online.
That is not very relevant. Be that as it may, the award of the tribunal appointing the blame 50%, that is not very relevant.
Again, in this case, there was readiness to work.
Yes.
In this case, there was a letter saying we are ready to work.
Yes.
Dada, please.
That is different. Everything depends on the facts and circumstances. It is up to the industrial adjudicator to appreciate that, because whether a strike is illegal or a lockout is illegal, it is very easy to. But whether a strike is justified or lockout is, it is not very easy to decide. লিখা আছে প্যারাগ্রাফ নাম্বার 250. Mumbai Mosque Sabha I have referred, no?
Yes. Referred.
Some time is available, no? May I read the evidence or your lordship will go through that evidence? The workers' evidence.
Workers' evidence, which part do you want to refer?
Exhibit, page number to have not written. Very simple, short. That will clarify our case. Last দিক দেখো। দেখো তো এভিডেন্সটা দেখো না, কোর্টকে দিয়ে দেওয়া যায় নাকি স্ট্রেট হতে।
Because I also want to reply. Which are the exhibits you'd like to? Which are the exhibits you'd like to?
I can give some other day.
No problem, no problem.
It's already practically time is over.
Practically time
It's already dark.
All right, let us learn something.
Hmm?
This is discussion. We'll make some study.
Good part.
That page, I'm just referring. I'm just giving you the page number.
Paper book.
Okay, udah tahu, udah balik dan kopi di kita. Exhibit. কত নাম্বার আসছে?
কোনটা?
এভিডেন্সটা? এক্সিবিট নাম্বারটা কত আছে? With L. Page number?
Number লেখা নাই।
Exhibit numbers also you can just tell us. So that,
Exhibit number L, etc. May I pass it to Mahin? That will be better. I will take it back.
we'll have it copied, no problem.
Huh?
We'll have it copied, no problem.
The exhibit numbers you can tell us so that we can refer. Exhibit numbers.
Acha.
Or
Yes,
put it
yes.
this way,
It will be his problem.
Otherwise,
make
I
it,
have no idea.
if you make 2 copies and have it, give one to.
We have the exhibits, we only want to know the exhibit numbers.
The numbers.
What are the markings? We will verify.
I can give it tomorrow. Tomorrow, about 5 minutes time. Just come
But
complete.
exhibit,
No, how much longer will you take to
About
complete?
5 to 10 minutes.
the exhibit alphabets,
Total?
Mine.
You'll round up in 5 to 10 minutes.
Yeah. Or
then let
let it be 15 minutes.
Let it be half an hour.
5 to 10 minutes, let it be today. At least it will conclude. it.
One part we can conclude.
Because so far this thing is concerned.
Firstly, source 4:30, we have got 10 minutes.
Of these exhibits.
Firstly, source 4:30, so we have got 10 minutes.
The purpose.
Let us try and conclude.
Okay, let me read it out.
Yes.
Let me read it out. You are take it. 140 or not.
Exhibit number?
I will give it the number.
MN.
All numbers I will give you numbers.
Just a minute, sir.
Whether evidence was properly appreciated or.
DD does.
I'll
Yes,
give
sir.
give it number right now.
Yes, sir.
Let me read out the evidence.
Ah.
I see Diana, no, let me skip. I had joined service Assam. Number 2, that my union has instructed me to appear in this. From paragraph 3 is the reason. That my union used to place its demand, known as charter demand, before the management. The demands are pertaining to the wages and facilities to its members employed in the establishment and used to get time settlement for a specific period. What will I actually give it into photocopy? Security management, the demands are pertaining to the wages and facilities to its members employed in the establishment and used to get signed settlement for a specific period. As per terms of memorandum of settlement, MOS dated 10/5/2005, the terms and conditions thereof, a new now A new MOS was to be operation from 2007. First memorandum of settlement expired. And new memo terms of settlement has to be operated. For that operation, for that purpose, they submitted a charter of demand. Was to be in operation from 1/7/2007. The union had submitted its charter of demand for new settlement before the management. I got it.
Yes.
Let us start from paragraph 3. That my union used to place its demands, known as charter of demand, COD, before the management. The demands are pertaining to the wages and facilities to its members employed in the establishment and used to get the signed settlement for a specific period. As per terms of Memorandum of Settlement, MOS dated 10/5/2005, terms and condition number 1 thereof, a new MOS was to be in operation from 1/7/2007. The period has been expired, a tenure expired and new operation has to be appointed. The union had submitted its COD before the management in March ahead of the time, but the management had not taken any steps to settle the COD, that is charter of demand, by executing new MOS and arbitrarily, unlawfully declared lockout of the establishment with effect from 1/2007 to 25/7/2008. During the lockout periods, the management used various steps against the leaders of the union, and in such circumstances, some of the members have succeeded to form another trade union. The date is probably good. Correct. They succeeded to form another trade union in the establishment, namely the Assam Carbon Staff and Workers Union, ACSW. That without following the established norms and rules of the industrial relation code discipline, the management has executed a memorandum of settlement, MOS, on 23/7/2008. With the newly formed SACWU instead of ACWEU, the management has made reference of the said MOS. The executive number, lockout notice dated 7/12/2000 as the ground of lockout. The management has already, that is the document which has submitted by the management. I am relying on those documents. The management has already executed 35 numbers of letters. Number of letters here. All these letters speaks about the holding of discussion. We are requesting the management, please come with the discussion. All these letters speaks about for holding of discussion without setting a precondition and setting the issue of the dispute so as the union can lead the path of agitation. Your Honor, your Honorable Court may kindly be pleased to treat them as exhibit from the side of the workmen union also. The document which the management exhibited, let us be considered it is our document. And thereby we are admitting all those documents. Now, Miller Exhibit A is the memorandum of earlier memorandum of settlement. Exhibit B, letter dated addressed to the management requiring where number of documents are there. I'm just simply trying some. These are our documents. Union letter 24,400, reply of the management letters, union letter, union. We have done all these documents. And after going through these documents, the learned presiding officer, though not put in a detail, simply he stated that a charter of demand was submitted, 10 workers were dismissed, bonus issue was not resolved, the workman side issued a number of letters from time to time. Management did not consider all these documents and the local outcome. So according to the presiding officer, both the union as well as the management responsible. Whether it is a perverse or not, evidence slightly marshaled, though not in detail, the relevant portions.
Highwayটা তো highways
Yes, sir.
Submission, but so far the judgments are concerned, here so this current presiding officer was the judgment of Statesman Limited.
Oh. This is the file. This is the file.
My argument.
So, basically your argument is when the reasons have been given, the flow of the evidence.
And not only that,
And
the reasons are given and whether these reasons are justifiable. Simply because a man gives some reasons.
yes.
Without
No, I understand that.
without having the foundation of
That
law.
will be there, but
Whether he has committed any error apparent on the face of the record. Whether this error is amounts to error of law or error material on record. One thing that but the error of law is concerned, that I have tried your lordship to pursue by referring all judgments, which my learned senior. Another thing is that, though it is, I will very frankly, your lordship express it, though it is not specifically stated, the award, due to elapse of time, the lockout became, though a line has been stated, but not specifically mentioned. Initially, a lockout may be legal, but elapse of time it may be illegal. One line has been stated. So whether that is applicable in this case or not, that has not been mentioned. But one line has been stated. Somewhere I got it.
Sir, when would you like to? We'll keep it.
If it is possible, in the second half tomorrow, if we get some opportunity, say if I get 15-20 minutes in second half, the first half will be possible.
Tomorrow it will not be, I'm told it is not.
Tomorrow is Friday.
I'm told it is change for me.
Oh, oh.
Actually, the matter is not part of it.
Real bench with,
Oh.
if we take it up, part hard হলে তো আহিব লাগিব supplementary.
The difficulty is not next week.
No,
Next week will not. No.
Any date, any date.
And
no,
any date,
for the next
any date is a question mark for me at least.
No,
Let
no,
me
no,
explain.
it is subject to your convenience.
No, no, next week, election petition is there, so I have to be in Itanagar Bank.
Next week.
So that is why, in that case, my lord, I can finish it up. Earliest. Where is mine? Where is mine?
F40.
Except 18 or 18.
Huh?
December, huh?
28 no?
Sorry, 14 December or 18 December.
Could it be on,
I would be wary of keeping it in the last week because
could it be, my lord, next week, Friday itself, 5th of December?
that we can do.
5th of December, because I won't take much time, only 15, 20 minutes. I'll finish it. 5th of December.
Assisted by Mr. Swenson. Mr. Ansel. Assisted by Ms. So,
Vilas.
who has concluded his arguments.
Some of the exhibits are concerned. I may
One or two
look at
clarifications
one or
here and
two
there,
minutes.
there is no difficulty.
I may look at 1 or 2 minutes time too.
We'll look at it. And list again on 5th
Print
of
out those-
December 2025 for reply by petitioners.
Point out those exhibits only. This special, I will not have a problem.
You-
Carry on. Put that off.